Call the list, please.
Commercial division method, item number 2, to be mentioned, Tata Financial.
My lord.
I am for the respondents.
My lord, I am for
Mandated
the
by law.
petitioner, my lord.
In this
My lord,
matter,
Yes, yes, there's a mistake in the coster.
My lord, and there
Act-
has been a settlement done, my lord, on 15th of May 2023. We wish to withdraw the matter, but the problem is that on 21st June 2023, a warrant of arrest has been issued, which may be recalled, my lord.
You're representing all the judgment at all.
yes, ma'am.
The advocate on record of the petitioner submits that the parties have settled the matter and wishes to withdraw the execution case. Stop. The order dated 21st June 2023 requires to be corrected as it mentions AP 435 of 2022, which should read as EC 435 of 2022. Number to ठीक है के नहीं छोड़ता SG. Stop. The correction should be made in the order and be treated as part thereof. Stop. Next. EC 435 of 2022 is accordingly dismissed as withdrawn. Interim orders, if any, shall stand vacated, and the warrants of arrest stand discharged.
My lord.
Please oblige, my lord.
Item number 3,
Lordship, this is my execution application. Lordship, the matter has been settled between the parties and a no dispute certificate has also been given. Lordship, I wish to withdraw this application.
The advocate on record for the petitioner submits that the matter has been settled between the parties, and the petitioner has also issued a no due, capitals, no due certificate to the respondents, to the award debtors. Stop. EC 466 of 2022 is accordingly dismissed as withdrawn. Interim orders, if any, shall stand vacated, and warrants of arrest, if any, shall stand discharged.
item number 4, JCL Infra.
Yes, my lord. Lords, section 11 petition, my lord. Lords, I just want your full consideration of
Microphone, please.
volume 2, my lords. Page number, lords, what's happened, lords, I will just clear it.
Microphone, please. You have to learn to use the microphone. Yes,
Sorry, my lords.
yes.
Lords, if you will see the page number 265.
Where is
annexure
the
K.
affidavit of service?
Pardon, lords, we have already served them. Lords, the service has already been done, my lord. Lord, the service has already been done. On last date of hearing, they have appeared, my lord. Yes, my lord.
They appeared on the last day.
Yes, my lord, somebody has appeared, my lord, on last date of hearing, my lord.
Are you coming from outside?
Yes, my lord, I am coming
Oh,
from Delhi.
you're there, Miss
Yes, ma'am.
Banerjee? Yes.
My lord, I just wanted two things.
I can't hear you. Please use the microphone. Why can't you
Sorry,
understand what the
Sorry,
court is
sorry,
saying?
extremely sorry, my lord.
Yes.
My lords, kindly see the volume 2, my lords. That is very important, my lords. I am here for appointment, my lord. What's happened? In 2010, I have invoked the arbitration, my lord. They have appointed the arbitrator in 2013, my lord.
Yes.
Thereafter, that tribunal has continued till 2016, my lord.
Yes.
Again, the officers of the railway has been retired, my lord, or somebody has transferred, my lord. Then they have formed another tribunal.
So it's a 11 or a 14?
11, my lords. My lords, what happened, my lord? That's why, my lords, I just want your kind consideration on
No,
volume.
but I don't understand. If the arbitrators were already appointed and they carried on their duties for a while and then they retired, will it be 11 or a 14?
My lords, 11, my lords. My lords, now I just,
Seven?
yes, my lords.
What's 7? 7 is an arbitration
Not my
agreement.
lord, 11.
11.
Yes, my lords.
Why would
Why,
it be
why I
11?
have come, my lords? 3 tribunal has been appointed, my lords. All have retired, my lords. The already third one has already heard the argument, my lords. It was only for the certain clarification.
Look at 15, please. 15 is upon a substitute arbitrator being appointed, the
No, my
arbitrator will continue with whatever work had been done before.
My lords, they have given the note in November 2022, my lords. One notice they have given us fresh panel, my lords. I have refused that, my lords. Reason being, I just want to be independent arbitrator, my lords. Finish it, my lord. 2010 onwards, my lords. I am fighting, my lords.
What
Yes,
is
my
it?
lord, it is not maintainable, my lord.
Yes,
The last sitting took place on, my lord, 10th March 2022.
Yes.
yes. Show me the
Thereafter,
page,
my lord,
please. Show me the page, please.
sir, kindly come to page 268, that is third sitting, which was held on 19th November 2020.
My lords, I have
268,
already
volume two.
annexed at page 268.
There is a system in my court.
Sorry, my lords. My lords,
You make your submissions, finish it.
my lords, you-
I will hear Mrs. Banerjee, then I will
Sorry.
come back to you. All right. No simultaneous submissions, please. Yes, if you want to say something, please say it. Your name is
Fayaz, my lords.
Fayaz.
Yes.
Yes,
My
please.
lords, page 268, what you have asked, my lords. It is a third arbitrator's meeting held on 19/11/2020.
268.
Yes, my lords.
What is the date of this document?
Volume 2, my lords.
What is the
A
date
ninth.
of this document?
My lords, is a third 19/11/2020, my lords.
Where do I get that from?
My lord, at the top, left-hand side.
My lords, order sheet number 3, 19/11/2020. My lords, on the top, my lords, left
Yes,
hand side.
yes.
My lords, a third arbitrator sitting held, my lords. And thereafter, my lords, I'm just reading the last, my lord. The first reference under this, my lords, 269, my lords, on the page, para 8, my lord. The first reference under the arbitration case was made with Mr. JCL India Limited on 9/9/2019. Thereby, prior to more than 1 year have already been passed on date. Therefore, the consent of both the parties that the claimant and respondent is required before final publication of the award. In this meeting, both the parties have agreed to continue with the arbitration proceeding. The consent is required as per the stipulation contained in section 29A. Arbitrator next date and venue of the sitting will be intimated in due course, my lords. Thereafter, my lords, one meeting has been held, my lords. On that day, my lords, nobody has turned up from the railway, my lords. In that,
You are the claimant.
yes, my lords, I am a claimant, my lord. And my lords, what they have done, my lords, now, my lords, I am just coming.
If you're saying that the mandate of the arbitral tribunal has terminated, you say that. Make the argument under 29A1. You have to say that they have become de jure or de facto
Yes, my lords,
ineligible.
as per the order also, my lord. That's why, my lords, I am saying, my lord.
It's a question of law, Mr.
Yes,
Fayaz.
yes, my lords, I agree with
Question
you.
of law. So please argue that.
My lords, now mandate has also gone, my lords, as well as
Mandate has gone according to what? Which section?
my lords, because they have extended, my lords. But my lords, in between, my lords, what they have done, my lords, they have given a fresh arbitrator panel, my lord, which I am not agreeing with. My lords, I just want that let any independent arbitrator will be appointed. He will conclude
Mr. Fayaz, please, if you're not ready, take time.
No, my lords,
It's a question of law. If you're saying that the mandate has terminated, you will have to show the provision under which the mandate has terminated. It's not a question of facts. You're writing letters showing documents. No, it has to be a 14-15 ground. It can also be a 29A1.
Yes,
So
ma'am.
please argue that point. Don't just show me documents. You're writing letters and all that. It's a question of law.
My lords, I agree, my lords. I agree, my lords. My lords, there was a mandate, my lord. They have written a letter within time, my lords. But
Again, you're going on saying, if it's a 29A1 point,
Yes,
then you
Lord.
have to give me the date. The dates.
my lords,
Yes, learned counsel needs to get ready in the matter. When will you come back? Are you traveling from my
yes,
outside?
ma'am.
You're coming from where?
Delhi, my lords.
Delhi.
Yes, ma'am.
Give me a date when you can also appear online. There's no problem.
All right, my lords. I will appear online.
Yes, please
On
do.
these aspects, my lord, what you have pointed out.
Yes, yes. Why do you need to come physically to the court?
It's
Please
all right.
appear online. When do you want to come back?
My lords, say in convenient, my lord, after 2 weeks, my lords.
After 2 weeks.
Or
Up to you. I'm telling you, but it's not an 11 point. It has to be a substitution point. Learned counsel appearing for the petitioner needs to get ready in the matter. No, seeks time to get ready in the matter. Stop.
Time.
List this matter. Give me a date, please, which is convenient for you. You can appear online.
Lots on 17th of this month.
17th. List this matter on 17 July 2023 as prayed for. Stop. If you're saying that the arbitrator's mandate has terminated, it's a
Yes, my
point of
29
law.
milords.
It's a point of law.
Yes.
And if you're saying 29A1, then you have to give the court the dates as to when the mandate
Mandate
terminated.
has been terminated.
Yes,
milord,
so
I think
because 29A1 says up 1 year from the
1 year and
completion of
after
pleadings.
extension. Yes, milord.
So you have to give those dates. How can you just say you want another arbitrator? And particularly when the document at 268 shows that there were at least 3 sittings held.
Yes, milord. There are already 3 sitting milords.
Very
and-
well, yes, call on the next matter. You will not understand. Negative. Call on the next matter.
Item number 5, Cholamandalam Investment.
This is my application. I'm for the petitioner, my lord. As per your lordship's last direction, my lord, we had intimated the advocate on record that this matter will be taken up today. In fact, I had pointed out to your lordships.
This is a 11 matter.
It's a
No,
section 9 matter,
9.
my lord. I'll just indicate your lordships the background, my lord. I had indicated.
Have you communicated to the
I've
respondent?
communicated to the respondents on the
Show me
advocate.
show me the communication, please.
The advocate on record has received this letter on 5th of July. We have intimated that this matter will be taken up today.
5th July. And they are based where? The respondent?
Respondents are based in Raipur in Chhattisgarh.
So the order is of 3rd July. Why did you communicate on the 4th? And they received on the 5th. Today we are on 7th. Come back on Monday.
That
please.
4th, I'm told that 4th, the advocate on record was not available. We tried intimating him. Thereafter, my lord, we had intimated him on 5th of July.
Very well. What is the point?
Lord,
It's a 9. Yes.
Section 9 application, my lord. Lord, the background of this matter was that we had advanced a loan. They had defaulted in repayment, my lord.
Yes.
Thereafter, we had filed a section 9 application, my lord, praying for certain interim reliefs. Lord, the
Yes.
coordinate bench had passed an order on 28th of February 2023. Lord,
Yes.
directing the respondents that why security to the extent of the outstanding amount should not be furnished. Lord, they were
So had posed the question to the
show cause,
respondent.
yes. And the matter was kept, my lord, on a subsequent date, which is on 28th of March 2023. On
So
that,
after one month.
yes, after 1 month, on that particular day also, the respondents failed to appear. Thereafter, my lord, this coordinate bench of this honorable court was pleased to grant directions, my lord, in terms of prayer C of the notice of motion, my lord, handing over the property which is situated in Raipur. My lord, may I invite your lordship's attention to the order dated
Yes.
28th of March 2023.
Yes.
Your lordships will see, my lord, that after considering the facts and circumstances, the coordinate bench of this honorable court passed an order in terms of prayer C of the notice of motion.
What is prayer C?
But prayer C is for handing over, my lord, physical possession of a shop room which is situated, my lord, belonging to the respondents, my lord, which is situated at Raipur, Chhattisgarh, my lord.
Shop room.
Yes, ma'am.
Yes.
And a receiver was appointed. Lord, and receiver was appointed. Lord, accordingly, the receiver went to take possession of the property.
Yes.
My lord, on 24th of April, my lord, the receiver, my lord, sought police help in order to take possession because there was significant resistance which was there from the respondents, my lord.
Yes.
Lord, the police stations, my lord, the nearest police station, my lord, failed to give any, my lord, assistance to the receiver. But following which, my lord, this was also intimated to this honorable court. On 18th of May, my lord, the coordinate bench of this honorable court was once again pleased to direct, my lord, if your lordship sees the order dated 18th of May. In fact, the
Yes.
receiver's report would also indicate
Yes.
that she was being resisted to take physical possession of this property. Accordingly, this was communicated, my lord, pointed out to this honorable court when
Yes.
the honorable court directed the Inspector General of Police, my lord, to look into this matter personally and furnish a report before this court by 15th of June.
Yes.
But what we find is, my lord, we have, after passing of this order, we addressed a letter to the Inspector General of Raipur asking him that if he is willing to render any assistance or comply with the order. But yet, my lord, no communication has come from his side. My lord, he was supposed to furnish a report before this honorable court. My lord, today I was only.
And have you communicated this order on the Inspector General?
Yes, my lord, we have communicated this order on 25th of May 2023. May I just place the copy of the order?
25th May?
25th May, my lord, we had addressed a letter.
Yes.
I'm told that this letter is already on record, my lord. In spite of, my lord, the communicating the same, my lord, no steps have been taken, my lord. But today I'm only praying, my lord, if the Inspector General of Raipur can be directed, my lord, to file a report so that the receiver may once again go and my lord can try to take, my lord, physical possession of this property, my lord, because this is an admitted case of default where the respondents are adamant that they will not comply with the orders and neither will they repay the dues which is due and outstanding. And on some of the days, my lord, the advocate on record for the respondents appeared. Thereafter, lord, the next day he failed to appear. So this has been the conduct of the respondent from day one.
1 minute, please. Yes, there appears to be a report of the Inspector General in the records. So I am directing that a copy be given to you and I keep the matter on Monday.
But in the meantime, I was also,
No.
my lord,
Consider the report
Very
and
well.
then come back.
very well.
Because without seeing the contents of the report, you can't ask for further orders.
Very well.
The report mentions something which you should know. Learned counsel for the petitioner places 2 orders of a coordinate bench dated 28th March and 18th May 2023, where the court directed the receiver to take symbolic/physical possession of the shop room of the respondent situated at Prayer C is not complete or what? Look at page 10 of the application, please. Prayer C is not complete.
It is not complete, my lord. In fact, I had pointed out, my lord, when I was briefed in this matter. Lord, in the notice
So
of
where, how will the court get a complete Prayer C? You're asking for
in the notice,
orders in terms of Prayer C
I-
and you're relying on orders passed by a learned single judge, but the Prayer C is not complete.
I bow down before your lordships, my lord. The complete description is there in the notice of motion, my lord. And in fact,
At
advised them
ki
to-
bolam, situated at Raipur, Chhattisgarh. Stop.
My lord,
It may be pointed out that that Prayer C in the petition is not complete. Stop. Next, the report of the Inspector General, the translated version of the report of the Inspector General, Chhattisgarh, is the Deputy Inspector General of Police, Raipur, Chhattisgarh, is on, has been placed for the court's perusal by the registrar, original side. Stop. The parties shall be at liberty to inspect the translated copy of the report. Stop. Before any further orders are considered or passed in the section 9 application. Stop. Next, list this matter Monday, Tuesday,
My lord, I'm just appearing. I got stuck in and I'm
Monday or Tuesday.
Tuesday, my lord.
List this matter on 11 July 2023.
I just want to submit that just one thing, that an OTS settlement is being explored. I have got a letter signed by Cholamandalam. So an OTS is being explored,
What is OTS?
one-time settlement.
Don't use abbreviations, please.
I'm so sorry. I
Are you
We
aware?
have no instructions. We'll come
have
back
got
with
an official
instructions,
letter. My lord, I have got an official letter signed by somebody concerned on behalf of Cholamandalam.
Learned counsel appearing for the award debtor, for the respondent, seeks to place a letter showing that the respondent is exploring a one-time settlement. Stop.
May a copy of this letter be?
Yes,
I'll
a
serve it.
copy of the respondent, counsel shall hand up a copy of this letter on the advocate on record of the to the advocate on record of the petition.
Grateful.
Grateful.
And correct the prayer, please, in the
We shall
petition.
make necessary changes.
Yes,
Grateful.
within the returnable date. Yes, the petitioner, the advocate on record, the petitioner is given leave to correct prayer C in the petition. In the meantime.
Great.
Call on the next matter, please.
6, Stray Equipment Finance.
My lord, this is my section 9 application. My lord, this was with regard to, my lord, assignment agreement, wherein, my lord, after the assignment, the, my lord, bank to whom I have assigned, my lord, was entitled, my lord, to collect the entire receivables except, my lord, 10%, which is the GST component, which I was paying to the statutory authority. So he has to, my lord, reimburse that from the, my lord, escrow account, which is being maintained. Now, for a long time, my lord, they did not do it. My lord, therefore, my lord, we issued them a notice. My lord, the bank did not do it.
Yes.
And thereafter, my lord, I issued them a notice for demand. My lord, since they, my lord, after receiving, did not even reply to it. So, my lord, we filed the section 9 application seeking an injunction, my lord, over that escrow account till, my lord, the arbitration proceedings are held or further orders by this court or the arbitrator, my lord. I had showed yesterday, my lord, the agreement where, my lord, it is specifically stated that, my lord, the GST component has to be given to me. It cannot be, my lord, retained by them because it's a statutory due which I am paying. It is not my profit. My lord, apropos that, my lord, my learned friend was to make his submissions, then I'll give a reply, my lord.
Her submission.
Yes, her submissions, and I'll give a reply, my lord.
Yes. Yes, Ms. Gandhi, microphone, please.
Yes, my lord. My lord, on the other occasion, I had submitted that I would rely on this agreement itself. But before I start, my lord, just one small correction, my lord. On the last occasion, my learned senior had indicated that, my lord, the customer is the borrower. My lord, the customer is not the borrower of the bank. My lord, in terms of the RBI guidelines, my lord, this particular customer is basically, my lord, a debtor.
Customer is the petitioner.
No, my lord, the customer is, my lord, the person whose rent is being received by the bank. And the customer on behalf of the assigner, who's the petitioner, my lord, is depositing this rent on his instruction upon certain agreements, my lord, to the bank. So, my lord, this customer, my lord, ideally, my lord, this customer is not the borrower of the bank. My lord, he is a debtor of the petitioner who is supposed to discharge his liability, my lord, to the petitioner. But in view of certain assignment and lease rental agreements, my lord, he is depositing that rental amount with the bank in the said depository or the escrow account. Now, my lord, I also have, my lord, the circular.
So you're saying that there is no privity of contract between you and the borrower?
My lord, there is no privity of any sort of contract, my lord, between me and the customer. My lord, I have an agreement with the my lord, the petitioner, my lord, who's the assigner. My lord, there is only one document, my
But the
lord.
borrower is your customer.
My lord, my customer, my lord, my customer is the petitioner, Shrey, and he is my borrower.
Yes.
And my lord, I am supposed to receive a lot of outstanding dues from it, which is not, my lord, the subject matter here. The subject matter here is, my lord, the rent receivable, which was, my lord, assigned by the petitioner to be received in the depository, in the, my lord, the escrow account of my client on behalf of the assigner, because, my lord, the assigner had certain dues with the bank. So, my lord, the agreement was executed in a manner so that whatever receivables is due to, my lord, the petitioner is deposited in the escrow account. And, my lord, yes, there is a clause in the agreement indeed that, my lord, if there are certain other dues, indirect taxes or statutory dues, which is also being paid by such customer in my bank's account, in the escrow account, my lord, I have
Say
to.
customer is the petitioner.
No, my lord, there are 4 petitions here. So
Yes.
there are 4 different, my lord, debtors of the assigner.
Yes.
My lord, so we, my lord, in terms of this agreement, we refer them as
Customer is the petitioner's is the
Debtor.
petitioner's debtor.
Yes, my lord.
And who is the assigner?
Assigner is, my
Petitioner
lord, the
assigner.
petitioner. Yes, my lord.
Yes.
My lord, if for your lordship's convenience, my lord, if your
And
lordship.
the assignee is you.
Yes, my lord. My lord, just the 3 definitions, my lord, as per the RBI guidelines, my lord, would be of great help, my lord, if I may be allowed.
Yes, yes.
My lord, point 1, my lord, it defines assigner, assignee, and the debtor.
Yes. And where is this from? Where are
My lord,
these
from the
definitions from?
my lord, this is the first page indicates it's RBI circular dated 2015.
Very well. Yes.
But this is just for clarification, my lord, who is a debtor. It has
That's all
nothing-
right. I need to understand. That's fine. Yes.
Now, my lord, coming back to the agreement, my lord, there was a clause, my lord, as was indicated rightly by the petitioner, that is 2.3.e, wherein, my lord, it holds that it states that any amount, my lord, which is
Give me the
deposit-
page, please, Ms. Gandhi.
Yes, my lord, page 22, my lord, he had relied, and also, my lord, he had pointed this out, that 2.3.e, my lord,
Yes.
which states that the rentor, my lord, here rentor is the debtor of the assigner, transfers to the assignee any amount to be paid by the renter or the assigner, as the case may be, towards indirect taxes. Such amounts shall be transferred by the assignee to the assigner, and the assigner shall ensure to deposit the same with the regulatory authorities. My lord, I am not denying this clause. My lord, will kindly take, my lord, clause 2.7 at page 23.
Yes.
Lord, this clause states that if the amount in designated account paid in by the renter is not sufficient to satisfy all the receivables comprising part of the transferred interest and excluded amounts, then due under the relevant renting agreement, the amount will be first applied towards the receivables comprising part of the transferred interest, and any balance will be applied towards excluded amount. My lord, the last 2 lines are very important. The assignee undertakes to pay any amount in the designated account representing excluded amount to the assigner within 7 days of receiving a written request from them.
So assigned, the assignor is a petitioner. Who is
Yes,
the
my lord.
assignee?
My lord, the bank. Now, my lord, the assigner had a duty under this agreement, my lord, to immediately inform me every time, my lord, the rent is received in my account, that this is the rental dues and this is the part of whatever dues which has to be excluded from the receivable, and you are to credit it to me. My lord, there is not even a single document on record to establish that, my lord, the petitioner had written any request to my client. So, my lord, my client was not aware which part of the rent receivable is to be segregated from that and to be paid to them.
So if today the petitioner does that, then what?
No, my lord, the agreement says he has to do it immediately. Now, my lord, I have their own documents which says that if they would have written to me immediately while during the tenure of that agreement, because, my lord, the tenure has ended in 2023, my lord, some has ended in 2023, some have ended last
Which
year.
agreement? The assignment?
Yes, my lord. My lord, so
Ended as in it was a
my lord,
fixed
they've
term,
expired.
fixed term.
Yes, my lord, there was a term, my lord, and it is there in the agreement itself, specifies some have ended in June 23, some have ended in April, some in 2022. So, my lord, every month, my lord, as and when the rent is receivable, my lord, they are supposed to indicate what part of the due has to be excluded and paid to them, and my client is under an obligation to pay them within 7 days. My lord, there is not even a single document to show they have complied this part of the agreement. Now, my
Comply
lord,
with in the sense that they have not asked you. They have
Yes, my
not
lord, they
written
have
to
not
you to
written.
segregate.
my lord,
That's what
because,
you're saying.
yes, my lord, because, my lord, there is no document which indicates what amount of rent was paid every month, what was deposited every month in the escrow account. The only agreement that states is there will be some receivable or transferred interest on behalf of assigner, which will be deposited with the bank in the said designated account. But what is the quantum, and what part of the quantum forms has to be treated as excluded in amount, my lord, or the GST amount which the petitioner claims, my lord, has not been ever specified to me. They have to write it.
So, Ms. Gandhi, where does the clause say that
No, my lord, I will.
it is only upon the petitioner, the assignor, writing to you that you will segregate and release the
My
excluded
lord, they
amount?
have to inform me what part of the amount. My lord, this is the
which
my lord,
part of the-
2.7, which says that the assignee, that's the bank, undertakes to pay any amount in the designated account representing excluded amounts to the assigner
Very well.
within
So
7.
you're saying that you did not receive a written request, and then so you will not release.
That is one part, my lord. Now, my lord will kindly take clause 2.3a. My lord, this clause states that the assigner has, my lord, every month or whenever the rent was receivable, my lord, issues a receipt to the my lord, the debtor or the renter. And my lord, this receipt was not even shared with me, nor was it given to the bank, so that the bank gets an idea as to what part was the rent receivable and what was the excluded amount.
And the excluded amount is what is the excluded
No,
amount?
it is defined in the agreement itself. It's at page Lord, page 18. Lord, page 18, 1, 2, 3, 4, 5, 6. Lord, the
Yes.
sixth entry. Excluded amount means in relation to a renting agreement. Lord, C, they are basically concerned with C. Any interest taxes paid by the renter under the renting agreement and rental schedules. Lord, this renting agreement and schedule is not for part of the assignment agreement. So the bank is not aware, my lord, what is the due on account of rent receivable and what is the part of excluded amounts. Now, my lord, if your lordship will take clause 2.3a, my lord, which is appearing at page 22.
So the petitioner is saying that the petitioner has the right to the excluded amount or the other amount?
My lord, he says today that he has a right over the excluded amount, which forms part of the indirect taxes, which, my
That's
lord,
C.
yes, my
That's
lord,
C.
which he was supposed to receive from the renter and which was being deposited into the escrow account.
Yes.
So, my lord, in my humble submission, my lord, since the bills which were raised by the assigner were on the rentor and were not part of this agreement, nor was shared with my client, my lord, my client is not expected to know what part of the quantum which is being
So
deposited.
that was my question, Ms. Gandhi, that if the petitioner now lets you know, what will you do?
My lord, now, my lord, this is the stage when, my lord, the bank has exercised their general lien, my lord. Under section 171 of Contract Act, if any amount is due or if received in excess, my lord, the bank can adjust it against the shortfall payments or the outstanding dues which are lying with the in the loan account of the borrower. And, my lord, it very well forms part of, my lord, this agreement also, my lord, that any shortfall, my lord, would be adjusted.
Yes,
my
so
lord, and today
if
the
there's
situation
a delay in the performance of clause 2.7 on the part of the petitioner, assignor, then what happens? They lose the right to recover the amount.
My lord, then the agreement itself says that any shortfall would be adjusted by the bank toward from the excess amount which is deposited in such account. So, my lord, since Shrey today is already under CI, my lord, insolvency, my lord, they have a lot of, not today, my lord, since 2021, my lord, more than around 32, my lord, 20 crores are still lying due, which has not been admitted by the administrator. And, my lord, it is part of records which says, my lord, they themselves have said that the administrator has accepted that this 20 crores and odd, which has not been accepted or admitted by the my lord, administrator, my lord, is part of the rent receivable. So, my lord,
Not admitted by the administrator means what? The
lord,
administrator has not taken your
my
due
lord,
on
out
record.
of 45 or 46 crores that was total due from Shrey
Yes.
to my client, my lord, the
Yes.
administrator has admitted around 18 or 20 crores, my lord, and some part of it is yet to be, my lord, has not been admitted on the grounds that it is part of rent receivable and it does not form part of the outstanding which has to be, my lord, paid out of the CIRP. Now, my lord, one more thing, my lord, a very important another clause, my lord, which is arising from the designated account agreement, my lord, which appears at page 41. No, it's clause 4. The heading is operating procedures at page 40, and the clause starts from page 41. It says, unless instructed in advance, as provided in this agreement, any request for payment of any proceeds from the designated account shall be executed as per the assignment agreement and other transaction
Your
documents.
which clause?
My lord, clause 4, my lord, it starts from page 40. My lord,
Yes.
at the bottom, operating procedures.
Yes.
And my lord, the clause my lord, the relevant part of the clause begins from page 41 top.
Yes.
My lord, that any advance payment, my lord, which my client was supposed to make to them, my lord, has to be intimated in advance to my client so that they can make that payment or release it. My lord, that's what the clause says. Unless instructed in advance as provided in this agreement, any request for payment of any proceeds from the designated account shall be executed as per the assignment agreement. Then, my lord, we fall back on clause 2.7. Now, my lord, clause 5.4, my lord, in the same page.
Yes.
All monies or receivables received in the designated account shall, my lord, this is that lien clause, my lord, shall until used or applied in accordance with this agreement be held for the purposes for which they were received and shall be segregated from other funds and property and shall be clearly identifiable as being secured in favor of the assignee by all appropriate means, including by reference to the interest of the assignee in the names and other details. Lord, this is that clause of general lien, my lord, that any amount, my lord, which will be received and until, my lord, it has been adjusted and utilized against the rent receivable, my lord, will not be paid to them.
Yes.
My lord, these are the relevant clauses which I will rely on. Now coming to, my lord, the documents or, my lord, the submission made that my client has not replied to any of the demand notices, my lord, is completely wrong. My lord, rather I would say they have suppressed this letter. My lord, my client on 12th of January 2023 has replied to 3 of the letters written by the petitioner, my lord. May I
In
be-
terms of clause 2.7.
No, my lord, this is their demand, my lord, as submitted that none of the demand notices or the termination notice has been replied. My lord, this is the, I'm sorry, copy the chain. This is that notice. No, this has not been disclosed here. My lord, the 3 notices referred in the petition are dated 20 June 2022, 6th of August 2021,
Yes.
6th of August 2021, and my lord, 16th August 2022. My lord, these demand notices are appearing at pages 47, 55, and my lord, it's there in the petition. My lord, I'll just indicate the page number of the 3rd notice also. My lord, these have been consolidated. My lord, a consolidated reply has been given on 12th of January 2023 by my clients. My lord will see the subject reply to the legal notice dated 16th August 2022. And then, my lord, will kindly take the 2nd paragraph, my lord, the 2nd paragraph where the notice starts. I refer to the legal notice dated 6th August 21 received from Malik and Company, and the demand notice dated 20th June 2022.
Yes.
My lord, so in my humble submission, my lord, this notice has been suppressed, my lord, because this is in reply to their demand notices, where my client has categorically taken the same stand that since you have not intimated us from time to time, my lord, when the agreements were in subsistence, my lord, today coming up and asking for a consolidated amount, my lord, this would at least, my lord, in my humble submission, be not allowed before this honorable court, my lord. My lord, the second, my lord, one more important aspect of it is, my lord, in all their demand notices, my lord, they have claimed a sum of consolidated sum, my lord, different sums. My lord, in some notice, we would find a sum of 30 crores. In the other, we find 32 crores and odd. My lord, similarly, my submission was that, my lord, just a schedule prepared by the petitioner, my lord, before this honorable court saying that this is the amount due in the escrow amount, and or they are trying to realize or adjust so and so amount. My lord, will not suffice their submission unless they provide a proper statement, my lord, which is verified. My lord, they have just prepared.
No, have they not done that?
No, my lord, they have they have disclosed, my lord, statements like, my lord, at page 49, which is their self-prepared document, my lord. Page 49 is one such document. My lord, page 54 is another document. My lord, page 758 is, my lord, the another schedule enclosed to their demand. And my lord, out of three, my lord, 2 notices itself, my lord, the amount of the GST they wish to rely or they wish to claim from the bank, my lord, it varies.
Obviously, it will month by month.
My lord will kindly now take, my lord,
Miss
page.
Gandhi, your argument can either be that the petitioner is not entitled to any amount at all.
My lord, my
Because of the
argument is
petitioner,
before.
1 minute, let the court finish, then you can clarify that the petitioner is not entitled to any amount at all because of the delay, 2.7 or whatever that clause was, and the petitioner did not contemporaneously or within those 7 days ask you for the money. Or it can be that the petitioner's unilateral, one-sided calculations are required to be seen and considered by you. So which stand are you taking?
No, my lord, my most important submission, my lord, which is I'm yet to place is, my lord, they have already invoked section 21. My lord, my submission was, my lord, their very manifestation or, my lord, their intention to proceed in arbitration, my lord, they've already, my lord, exhausted that remedy, but they have not taken steps. My lord, in their own.
No, but if they invoke section 21, why not the petitioner? Why would any litigant be
No, my lord,
debarred from asking for a 9 relief?
indeed, my lord, section 9 is always open to them. But, my lord, what I wish to indicate is, my lord, they are misusing the powers, my lord, by coming before this section 9 honorable court, my lord, and seeking this remedy when, my lord, they've already invoked section 21 in November 2022, asking my client, my lord, to appoint an arbitrator. My lord, in my humble submission,
No,
within
have
30
you
days.
replied to that?
No, my lord, my client has not. So, my lord, I was.
So then they can ask for a section 9 relief. In
My
any
lord-
case, section 9 is before, during, after, whatever the. language
Definitely,
is.
my lord. But, my lord, I would like to place reliance on few judgments which say, my lord, if their very intention of proceeding with the arbitration, my lord, is not itself bona fide, my lord, then section.
Why is it not bona
My
fide?
lord, because this was the notice of November 2022. My lord,
Yes.
they've taken all the while 8 months to come before this court, my lord, when they could have already exercised their right under section 11 and have an arbitral tribunal appointed. And by then, possibly by now, my lord, they would have already got some order under section 17, which they are seeking before this honorable court.
That's speculative. Whether the court can't force a party to come to the court by way of a section 11(6) and get an arbitrator appointed. The court can always see whether the section 9 is maintainable or not.
Yes, my lord.
Section 9 is very wide, anytime, but before
Yes,
execution
my lord,
of the
before, my lord. Exactly. But, my lord, I was only relying on certain proposition which say that, my lord, the powers and the remedy under section 17, my lord, should not be taken, my lord, should not be overlooked or should not, my lord, the court should not usurp.
That's only
the
for
jurisdiction.
9(3).
Yes, my lord.
That's only when the relief under section 17 is not efficacious, then 9(3). But now even there's an ArcelorMittal, I think.
Yes, my lord. My lord, in ArcelorMittal itself, my lord, I was relying on few paragraphs where it says that, my lord, when they could have exhausted their remedy under section 7.
But ArcelorMittal is when the tribunal has already been
Yes, my lord.
constituted,
My lord, yes.
and whether the court has applied entertaining or whatever that those paragraphs are, applied its mind, whether the court can entertain or not, and it's softened down that position of 9(3).
Yes, my lord, but, my lord, a concept that my lord, their very intention, my lord, to proceed with the
No,
tribunal.
Ms. Gandhi, you can concentrate on this. Section 11 is not a good point. I'm telling you.
My lord, very well, I would
So
not.
just so that you can know the mind of the
My
court.
lord, my lord,
But
very well, I would.
definitely on the merits you can argue, but 11 is not a good
My lord,
point.
I would not hop on then, my lord, at least, my lord, on the ground of suppressions, my lord, that few documents have not been disclosed. And, my lord, their own document, my lord, one of the letters which they have enclosed in the petition, my lord, appearing at page. Lord, this was the first demand, I suppose, which had come from the petitioner, my lord.
Are you going to place documents which are not part
No,
of
my
the
lord, this is
reports?
part of their own document, page 46, my lord.
Yes.
The notice dated 20th June 2022.
Hmm.
Lord, they themselves have relied on the fact, my lord, that if a request would have been made within 7 days, my lord, from the demand made thereof, they would have they ought to be receiving this amount. My lord, my humble submission is, my lord, the most of these agreements, my lord, in fact, in all 4 cases, the agreements have completed their tenure. Now, my lord, if they come before this honorable court and seek a remedy, my lord, without having their facts to be adjudicated before the arbitral tribunal, my lord, in my humble submission, my lord, today before
There's no arbitral tribunal now.
yes, my lord, as of now, no, my lord, all I was seeking is, my lord, since they've already exhausted that, my lord, they ought to have proceeded there. Though, my lord, your lordship is already
No, I'm
expressed
just
me-
trying to help you. so that I can save your time, that's all. Yes.
My lord, in my humble submission, my lord, these were the basic points I would want to rely that since, my lord, that when these agreements were in subsistence, they ought to have provided me these details. And my lord, there and there, they would have got this amount. My lord, I am not saying that this amount was never payable to them in terms of the agreement, my lord. If they would have written to me in due time, I would have paid them. But my lord, then clause 5.4 also helps my client saying that there, if any excess amount, because my lord, they were not aware of what amount forms part of excluded indirect taxes sum and which is the rent receivable. So, my lord, in that case, my lord, what amount was deposited in excess, my client has adjusted it towards the dues, my lord, in respect of the same receivable account. My lord, there have been instances when the payments were not made in terms of what they ought to have been made. So they have adjusted it, my lord, accordingly for the shortfall of the receivables received, and my lord, exercise their banker's lien.
Very well. Thank you. Mr. Banerjee?
Yes, my lord. My lord, kindly takes, my lord, from her submissions only, my lord, it shows that I am entitled to the amount. Kindly comes to page 18, the definition that she has stated, excluded amounts. My lord, any indirect taxes paid by the renter under the renting agreement and relevant rental schedules. Now, my lord, this agreement of lease rentals is now with them. In the lease rental agreements, my lord, it is specifically stated, it is not with me any further, that, my lord, what is, my lord, the indirect taxes in the rental schedules and what is the, my lord, rentals under the agreement. So they are well aware of it. And that is why it is stated here under the renting agreements. It's very specific, my lord, and I'll rely on 171. She's not read 171. I'll rely on it, which, my lord, says that I am entitled to this amount. It says renting agreement and rental schedule. So renting agreement in the rental schedule specifies what is the indirect taxes component there and what is the rent component there. Firstly, my lord. Secondly, my lord, kindly comes to, my lord, 2.3, collection of receivables. See, my lord, page 22.
Yes.
In the event that the renter transferred to the assignee any amounts to be paid by the renter or the assignee, as the case may be towards indirect taxes, such amount shall be transferred by the assignee to the assignor, and the assignor shall ensure that the same is deposited with the relevant government and regulatory authorities as aforesaid. So therefore, my lord, this is an express provision in the agreement itself.
You are the assignor.
Yes, I am the
Assignee is
assignor.
the bank.
Yes. And renter is the, my lord, debtor of the assignor, which is assigned to them. So therefore, my lord, this is an express provision in terms of that definition clause, which I read out, that, my lord, the component of GST, as, my lord, the taxes, indirect taxes here is expressed here. And from there, he is to transfer this irrespective of what is extra or not extra, my lord, because that component is described. Now, my lord, kindly comes to one more, my lord, definition. Page 19, which is very important, my lord, which has not been relied upon. Tax, what is tax, my lord, under this agreement? Page 19, tax shall mean any direct or indirect tax, cess rate, or duty on sale or lease of, or on provision of any goods or services, and includes any tax deducted at source, excise duty, service tax, lease tax, transaction tax, import duty, export duty on import, export, manufacture, processing, or making of any goods or provision of service, and term taxes shall be constituted accordingly. So, my lord, the definition of tax is very much defined. And, my lord, the tax component is there in the rental schedules.
Mr. Banerjee, I don't think Ms. Gandhi's argument was that the bank can't understand what is to be paid. The defense is A, the request was not made on time
I'll show that
under
that is
2.7, and B, not segregable now.
Now, it is segregable because the agreement says so, that there is difference of tax component and rentals. And that is there in the lease agreement, which is not with me, which is with her, with the, my lord, renter. So therefore, that component, my lord, discloses it. If she discloses tomorrow in court, it will come before this court, my lord. Then, my lord, kindly sees, my lord, as I read, my lord, 2.3, that it is his obligation, my lord, to pay it to me. 2.3, clause C, an express obligation under the agreement. Oh, this is E. Well, I'm sorry, this is E, my lord. 2.3, clause E. There is an express obligation under the agreement. Then, my lord, kindly comes to the clause that, my lord, my page 4, 7 digit.
2.7.
2.7, my lord. Kindly takes that clause. page 23. If the amount is designated in the designated account paid in by the renter. So, my lord, the first criteria is that whether the renter has paid it or not
Yes.
is not sufficient to satisfy all the receivables comprising part of the transferred interest and excluded amount, then due under the relevant renting agreement, the amount will be first applied towards the receivables comprising part of the transferred interest, and the balance will be applied towards excluded amounts. The transferee undertakes to pay an amount in the designated account representing excluded amounts to the assignor within 7 days of receiving a written request to do so. Now, my lord, it nowhere says that, my lord, the money will, my lord, be a lien would be created over it if I don't, my lord, give him a request within 7 days. That money is to be kept in that designated account, my lord, for, my lord, the tax part or the excluded amount. This is very.
You're claiming the excluded amount.
Yes, I am, because that is also not mine. I have to pay it to the statutory authorities. My lord, this excluded amount has to be kept there. That is the clause. It is not, my lord, that if I don't, my lord, give him a request within 7 days, that excluded component or GST component can be usurped by him. It has to be kept there. He has to give an explanation as to why, my lord, this amount he has utilized, the bank has utilized, or, my lord, why it has not been kept in the escrow account. Otherwise, my lord, this concept of escrow account would not have come. It would have directly gone into the bank's account, any renter's rental schedule. This has been made so that in a unique way, by way of the subsequent, my lord,
designated account.
yes, that designated account is an escrow account, which, my lord, I have an access. The bank has also an access to it.
Yes.
So, my lord, that amount has to be kept there, irrespective of, my lord, whether, my lord, I request for it or I do not. He has to give an explanation why the statutory dues, my lord, he has used up. Now, my lord, now a new story has been stated that he has, my lord, the bank has certain dues against me. This agreement does not talk of that. This agreement is not with regard to that. That, my lord, under the CIRP, he has to apply before the, my lord, administrator. Administrator, my lord, he is named as an administrator, but usually he is an RP, my lord, the resolution professional, who would, my lord, adjudicate or, my lord, look into the claim.
Doesn't the IBC say resolution professional?
It
Where
is,
is this
it is.
administrator coming from?
I don't know.
RBI.
Since, my lord, the
Yes, my lord.
application was made by RBI, he is being termed as an administrator. There is no concept of
But
administrator.
same as a resolution professional.
His performance is that of a resolution professional. There is no term as administrator in IBC, my lord.
Yes.
In fact, my lord, the administrator.
IRP and then RP.
Yes. And then, my lord, subsequently, if it goes
Committee
into
of creditors
liquidation,
and
the
all.
liquidator will come in.
Liquidator.
My lord, then, my lord, if he makes his claim, the bank makes its claim, my lord, the administrator will give an opinion, adjudicate it, and, my lord, either, my lord, take the haircut and put his claim at a lesser amount or accept the entirety. That has nothing to do with this assignment agreement. He cannot say, my lord, the bank cannot say that I will, my lord, adjudicate and, my lord, keep that amount there, because today, under the CIRP, the administrator has stepped into that account. That account is also now controlled by the administrator in a way that the bank cannot, my lord, do anything with that account, my lord, unless, my lord, he, my lord, satisfies to the administrator. So therefore, this concept of saying that I have a due, that will
Very
not
well.
prevail.
That is all, Mr.
No, my lord,
Raj?
there is one more thing, my lord. Now, my lord, kindly sees, my lord, it has been stated that I have not made demands. Now, kindly sees all these demands are made right from, my lord, 20th of June 2020.
Mr. Banerjee, do this as well as Ms. Gandhi. I'm giving you till Wednesday. Just give me one page of the page numbers,
Yes.
reference page numbers under the points. All
Yes,
right. Basically, you have raised 2 points. So you have to defend the 2 points.
My lord, page 46, if your lordship comes, my lord, there is a demand notice, my lord, of 20th June 2020 in respect, my lord, of the account. And, my lord, I have given a details of my claim also at page 49, which is an annexure to that letter. My lord,
Yes.
these are the, my lord, accounts in which, my lord, the GSTs are due.
Yes.
So, my lord, prima facie, I have given, my lord, the details of the account from which the GSTs are due. Now, my lord, if lordship, my lord, in section 9, the court will not go into the adjudication of the accounts. That's the part of the arbitrator. If your lordship wants, I can give it, because there is nothing to hide. This is a GST account. I am not going to gain out of it. I can disclose it before the court even. But, my lord, preferably always, this is the part which will go for arbitration, for which the account has to be secured till that time. So there is an explanation of each account given at page 49, which is part of the agreement, the demand notice. Page 51, there is again a demand notice, my lord, with respect to the same. Page 54, there is again a demand notice given to
That's
them.
all right, Mr.
Now, my lord,
Banerjee.
this letter that my learned friend has handed over, this, my lord, does not show even an acknowledgement. I have shown acknowledgement of each of the letters. This is, my lord, a printout, my lord, with greatest of respect from the, my lord, computer. This has got no relevance at all.
Notice of
No,
respect to, or to the computer. What are you saying?
my lord, this is with respect to, my lord, the letter I'm saying, my lord, it's been a printout from the computer.
Very well.
Now, my lord,
I'm
kindly
giving you
takes 171 once, my lord, which my
Yes.
learned friend has relied upon of the Contract Act.
Contract act.
This, in fact, helps me, my lord. When general liens are, my lord, done, not in these cases. General lien of bankers, my lord, I am not reading the rest. Bankers, in
Yes.
the absence, my lord, kindly sees the word, in the absence of a contract to the contrary, retain as security for a general balance of account any goods bailed to them, but no other persons have a right to retain as security for such balance goods bailed to them, unless there is an express contract to that effect. So, my lord, if there is a contract, this, my lord, lien will not apply. That is 171.
Very
Just
well.
contrary to what has been said.
Yes,
Okay.
I'm keeping it on Wednesday. Yes, heard learned counsel appearing for the petitioner and the petitioner within brackets assignor, close brackets, and the bank within brackets assignee, close brackets. Stop. Counsel appearing for the bank, for the respondent bank, has raised essentially two defenses to the petitioner's claim, semicolon, namely that the petitioner failed to comply with clause 2.7 of the agreement dated 17 January. Agreement for assignment, capitals, dated 17 January 2019, and that the petitioner has also failed to indicate the specification of the excluded amount which the petitioner claims as GST and indirect taxes dues from the bank. Stop. It's only GST, Mr. Banerjee?
Only GST component.
GST and indirect GST dues from the bank. Stop. Next, list this matter on 13 July 2023. Stop. Council are requested to indicate their points. Stop. Just one page, please.
Yes, great.
Grateful.
I don't know, 7.
Same, only the assignment agreement number is different and the date is different. Same order, my lord.
Yes, Aki, order.
8,
Same order, my lord.
Yes.
9.
Same order, my lord.
Next.
Grateful.
Item number 10, Mohit Mal.
So this is my section 9 application. My lord, I have served.
My lord, I appear for the respondent bank in this matter.
There are two respondents, my lord. I have served on them.
No, it's Motilal Rathi, that's the bank.
No, my lord.
Respondent
Motilal
number
Rathi
two.
is the respondent number 1, who is the director of a company, and 2 is the bank, my lord.
Small Industries Development
My
Bank.
lord, I have served. 1 has refused. 2 is appearing, my lord.
One, who is the main, this is 9.
Yes, section 9, my lord.
Yes.
I'm seeking for an interim relief. My lord, in
When
this,
did you serve one?
lord, 3rd July. 3rd July, my lord.
3rd July. And one is based in Bhavanipur.
Come back as refused. 1 has refused.
Doesn't say refused.
That's all.
Where are you finding refused?
I'm told,
It doesn't say.
My lord, may I mention one in the letter, it is written 8 July 2023.
The matter will be taken up.
Yes,
এটা তো item delivered.
which is a Saturday, so it appeared today.
Yes, Mr. Banerjee, which date did you mention the matter will be taken up? 8 July? Can't expect her to be ready then.
The letter says, my lord, will be taken up before Honorable My Lord on 7 July 2023 or soon thereafter.
May I show the
That is-
letter? my lord?
That has
Yes.
been enclosed here also. ma'am.
Show it to Mr. Banerjee.
Either.
This is not the letter I have received.
No, this is the service of the petition.
No, this is the original. My lord, may I place
পুরো
this?
দুটো কি করে হবে?
It is having the original signature and seal of the
এটাও তো আছে।
firm.
On 8 July. Mr. Banerjee, come back. I
May-
can't expect her to be ready.
No, no, that's all right. This
Yes,
says
yes.
7 July, my lord, I'll come
Yes,
back.
yes. Tell me, when will you be ready in the matter?
My lord, next week, my lord.
Tell me, 8th is a Saturday, so tell me whichever date is comfortable
Lord,
for you. I will
Lord.
keep the matter.
My lord, 13th.
13th. But you will argue. Don't get a senior, please. All right?
My lord, my senior is appearing in this matter.
You argue the matter. Your senior can sit
একটু
next
লিখে
to you.
রেখেছো।
Because I'm adjourning only because you said it's 8
Huh?
July.
এর নাম
Huh? 13th is all right?
Yes, my lord, only thing, my lord, I have enclosed a letter of theirs. My lord, the entire letter is with us, my lord. 2 pages have missed out in the petition. I can file that by way of a supplementary affidavit. I'll give a copy to her
Yes,
also. It's
yes.
part of the documents.
Grateful.
List this matter on 13th July 2023 as prayed for on behalf of the respondent. Stop. The petitioner is given leave to file a supplementary affidavit to bring certain documents on record, a copy of which will be served on the respondent by 10th July 2023.
তুমি এখানেই বসো। এখানেই বসো, তাহলে তোমাকেই serve করবো। ওকেই serve করবো। Grateful.
Grateful.
Item number 11, concrete developers.
For the respondents, your ladyship. Mr. Mitro was amidst his submissions, he was to conclude today. He was to hand up few
Mr.
judgments.
Mitro, देखिए last order.
Fair enough. I'm here, madam.
এইটা কি রেখে আসবে? Yes, Mr. Mukherjee, what was the point?
Well, this was one of the matter where,
You can sit down and take your breath
no, well, that's fine.
for 2 minutes. Yes.
That's fine, madam. This was the matter, madam, where a deceased partner's rights are being claimed.
Yes, yes,
by
yes,
the
I
son.
remember. Yes.
Well, section 17 order has been passed for security on the basis of the last balance sheet.
This is
on
the matter,
date of
there
the
was
death.
also the point of whether it's an order or an interim award.
Yes, my lord.
That was in the execution, your
That's it.
ladyship.
Yes.
Insofar as this is concerned, Mr. Mitro on the last occasion said that he'll hand up few judgments
Yes.
and
yes.
take about 20 minutes.
Well, I'll take Mr. Mitra's coming, my lord.
It
My lord, before that, your lordship will see the section 17 application, the scope of the application, where this order has been passed. Also, my lord, the section 17 application was to be heard along with the addition of party application. Lordship will recall here, my lord, the deceased partner had 3 legal heirs: his mother, wife, and son. The wife and son are together. The mother is not with them. So we had filed a specific application also for addition of party, where the grandmother ought to have also been added as a party, and that was also being heard. And the arbitrator had previously in a meeting held that this will be decided together, but this
Yes.
addition of party application has not been decided. So I'll show those, my lord. If your lordship takes the section 17 application, which is page 226,
Second volume.
second volume.
This is your section 17
No, my lord,
application.
there's section
There,
17
there's-
application where the order has been passed.
The claimant's section 17, your ladyship.
Your lord, my lord, the reliefs are at page 239.
Yes.
Well, at page 239 are the reliefs. Your Lordship, see the prayers which have been asked for. An order be passed directing the respondent to produce all books and financial statements for the financial years 2019, 2020, 2020, 21, 2021, 2022 with regard to the respondent number 1. An order be passed directing the respondent number 227 to furnish all books and accounts of the respondent number 1, setting out the details and particulars of the sale considerations received in respect of the self-contained flat number 4, A4, on the second floor of the multi-storied building, as also details and particulars of the consideration received in respect of the self-contained flat number 5A and flat number 5A in building, namely Raghu Estates, lying at 8/4, premises number 8/4, Alipur Road. Prayer C is a receiver be appointed for preserving the aforesaid sale consideration received by the respondent number 1 from the sale of the self-contained flat number A4 and 5A. No, not reading the rest of it. Prayer D, the receiver so appointed be directed to represent the 33.40% share of the late Pawan Kumar Chudiwal. Prayer E, an order of injunction restraining the respondent, their men agents and assigns from dealing with and or disposing of or alienating or transferring or encumbering the assets and properties of the respondent number 1, including the remaining flats. Well, this was a prayer which comes under section 17A, 17(1)A or 9(1)A, my lord. Prayer F, injunction against unilateral adoption of books and accounts of the financial statements of the respondent number 1 without representation of 33.40% shares. Add interim prayers in terms of prayers above and such further. There was no prayer for attachment of security, which has been granted. And my lord, your lordship, if your lordship takes the pleadings also of this application, there is no pleading which is in the line of Order 38, Rule 5, which has been made in this application as well. Subject to correction, if it can be pointed out, I have not found any pleadings in this application.
That needs to be made.
That has to be made, my lord.
And what about that Rahul S. Shah?
My lord, Justice Indira Banerjee's judgment.
No. 3-member bench, I think, presided by Justice Bobde, then CJI.
Well, there are recent judgments of Supreme Court which say that the pleadings of Order 38, Rule 5 and the case has to be made out. It's mandatory for that case to be made out for any order to be passed under Order 38, which is in the nature of security for a claim. And here, my lord, it's not a claim which has been accepted in any manner whatsoever. It's a disputed claim. And my lord, at the highest, what they are entitled to is, my lord, 25A and B, which my learned senior has shown, my lord. Section 25A and B, one is, my lord, that capital contribution and accumulated profit after deducting the accumulated
Mr. Mitro's
loss.
point was that it was negative balance.
It was negative balance. And my lord, your lordship will also see there is, my lord, I'll come to that also. My lord, there is a clause in the partnership deed, as also, my lord, in the Act, my lord, LLP Act, which says, my lord, they have to contribute for the losses that is required to be made by them. They've not done that. My lord, I'll show the section 33 of the LLP Act, if your lordship takes once. I'll come to that straight, my lord.
Yes. Yes.
There is no conflict between the Act and the partnership deed, my lord. The lordship will see section 33.
Yes.
Obligation to contribute. The obligation of a partner to contribute money or other property or other benefit or to perform services for a limited liability partnership shall be as per the limited liability partnership agreement. A creditor, well, not necessary. And now your lordship sees the partnership deed, which is volume 1.
No, 1 minute, please.
Yes,
Mr.
ma'am.
Mukherjee, what does 33 say?
The obligation of a partner to contribute money or other property or other benefit or to perform services for a
Yes.
limited liability partnership shall be as per the Limited Liability Partnership Act.
Yes.
And now your lordship will see the partnership deed, my lord, which is the agreement which is there.
Yes. Partnership agreement, do you
Yes,
want me
madam.
to see? Which
Partnership
page?
agreement. My lord, it starts at page 2. 44 and one of the relevant clause, the second volume. Is clause 16 at page 254.
That's 24th November 2015
Yes, my lord.
Yes, it's 20.
24th November 2015
at page 260
at 254.
to 54. Yes. Mr. Mukherjee, first tell me your point and then show me the document, please.
My lord, I want to show, my lord, it was their obligation to contribute also for the losses.
Yes, that was Mr. Mitra's point. I
Yes, my
remember
lord, but that's there in the deed as also, my lord, as per the act, my lord. And they have not done that. They've not done that. Your lordship will see clause 16, the losses. Losses of the of concrete developer LLP, including loss of capital, if any, shall be borne and paid by the partners in their following proportion. And my lord, here they are the seventh party, 33.40. So they were obligated under the act as also the deed to contribute to the losses. Having not done that, we've asked them to do it also. My lord, lordship will see, my lord, here, this volume only, my lord. Page
So,
2.
Mr. Mukherjee, what are you saying? That if they had contributed to the losses, then they would not have been entitled to any amount?
They first have to act as per the deed. And
Mr.
their
Mitra's
main prayer,
point was
my lord,
that negative balance.
negative balance,
That
my
is
lord.
there. But in any case, if they had contributed to the losses, then they wouldn't have
My
been.
lord, what is required for them is to contribute. Their
Yes.
entitlement is not here as yet, my lord. Entitlement will come as per 25A and B once there is a profit. As of now, my lord, once there is a net profit.
Yes.
My lord will give leave
Yes,
for my
yes.
learned senior to take it.
I will just, I covered my points. I will show that the documents in support and then.
Mr. Mitro, you wanted this today for only citing
Closing.
judgments.
Yes, well, point wise, I must show the point. Hello.
Mr. Mitro, if you want to show documents, 2 minutes for that, and then
2
you can
minutes,
go to the
absolutely 2 minutes.
decisions.
Well, I'll stick to that, Lordship.
Section 17.
Take the section 17.
17 is giving the-
Praise God. Lordship, the addition of party application was being heard together. That's another point. Addition of party of the mother, the grandmother of the thing.
Grandmother is not with them,
Not with them, they are now
with
claiming.
you.
What does she gain from it? This is a loss-making venture. She claimed her stake in her son's estate.
Yes.
And said that this boy Gaurav Churiwal, or a boy, a man,
The deceased partner's son.
this is partner's son, Pawan Churiwal's son, has no right to represent the estate because he had come as a sole, as he and his mother were the sole legal representative, suppressing the fact that grandmother is a legal representative on intestacy because there's no will here. So this I was showing on equity point of view. And the legal error of the learned judge the learned arbitrator was he had decided to hear both the applications together. Lordship, that is in 3 minutes. He was fixing them both for hearing. Addition of party and section 17. Because this goes to the root of the matter. 3 minutes of the meeting. Page 7, 10th, 11th, 12th. Meeting, I'm just reading out. I've given in my note where I've given the page number references in the last page of my note. So I will I've given in the last page 5 of
No,
my note.
what are these meetings, Mr. Mitro?
Hearings on the section 17 application,
Hearings.
17 and the addition of party, Lordship. That is because 775 is the 10th sitting
Yes.
where Lordship can see the section 17 application was being heard, which would be evident from 776 bottom,
Yes.
where he prima facie notes that it is not possible to determine at this stage. Our defense is noted. Our submissions on that day.
You're looking at 776.
776 at the bottom, the difficulty faces that although it can prima facie be held that there has been accreditation of revenue to the firm, in order to adjust the expenses, should be also liability. There cannot be any prima facie fine. Therefore, unless the parties agree on what should be the adjustments, it is not possible for the tribunal to direct the respondent to set apart a fixed amount. And thereafter, further submissions on section 17, 777, second, third paragraph, kindly come to the last paragraph of 777 by consent of second last paragraph. since Mr. Ghosh insists that his application for addition of party be also heard along
Mr.
with that
Ghosh was for the,
for us. He was
yes. Yes.
heard along with the section 17. And since there is no scope for passing any interim order thereon, the claimant may file its opposition to the same order before the next date. By consent of parties, the next date of the arbitration is fixed on 17th on virtual mode for further hearing on the application under section 70 as well as addition of party. This is repeated thereafter. Next sitting 779, where section 17 hearing resumes at 782. 782 by last paragraph, by consent of parties.
Mr.
Next,
Mitra, what is the point?
the point is addition of party and section 17 were heard together, were intended to be decided together. But one fine day we get the order on the section 17 application, and the addition of party remains pending, and that goes to the root of the matter. That's the point. The facts I've covered, Lordship, in not my note. It's in my
Why would it go to the root of the matter, Mr.?
because who will represent the claimant? Claimant is not a partner himself. He represents Pawan Churiwal. Pawan Churiwal, if he can be represented by 3 persons, so then until who will represent whose version do we hear? Because if I represent the estate of a deceased, then the estate has to be jointly represented. Unless, of course, there's an administrative pendentiality appointed by court who can represent, or the executor, as per the succession law I'm talking about. If there's no administrative pendentiality or executor, then it has to be the heirs in intestacy or the legatees jointly.
Yes.
That's obvious. So, till it's decided who can represent the estate of Pawan Churiwal, any order on the section on their in their favor cannot be passed. It's a non-joinder of a necessary party.
Very well. Yes.
So, that was the point, Lordship. Next I'm going to is, Lordship had put me a question on the equitable jurisdiction. Apart from the facts, I showed that he does not deserve equity. Lordship, I wanted to just show one judgment since 2007, volume 8 Supreme Court cases, page 600, which aptly distinguishes the law in UK and India so far as equity jurisdiction is concerned. There are many others, but then I'm just
Equity jurisdiction as in?
the court's equity jurisdiction.
So.
Arbitrator, of course, has no equitable jurisdiction. And he's a creature of statute. Short of moments of random thinking and eureka moments, which has become a part of our legal jargon now, part of random thinking and eureka moments apart, arbitrator, who's a creature of statute, cannot exercise inherent and equitable powers. But even a court, even a writ court, even equity court like section 9 interlocutory court cannot. Lordship will see paragraphs 26, 27 of this judgment.
620?
600 at 608.
Yes, which paragraph?
But 26 and 27.
608.
In England, the Court of Equity exercises jurisdiction in equity. The courts in India do not possess any such exclusive jurisdiction. The courts in India exercise jurisdiction both in equity as well as law, but exercise of equity jurisdiction is always subject to the provisions of law. If exercise of jurisdiction would violate the express provisions contained in law, here it is 24(5), and also the various laws on attachment for judgment, the same cannot be done. Equity jurisdiction can be exercised only when no law operates in the field. 27. A court of law cannot exercise its discretionary jurisdiction, dehors the statutory law. Its discretion must be exercised in terms of the existing statute.
So it's someone like 151.
151 also has to be subject to existing. Only Supreme Court has power under Article 142. Only Supreme Court for ends of justice. That has to be specially invoked and said in a judgment I am exercising Article 142 powers. A Lordship. Now here I'm showing this is contrary. He has relied upon 24(5), the learned arbitrator, and then he has, this is got the sum total of losses and liability, profits and losses. Now, no, now, Lordship, on the settled principle law, that if it's a money claim you're securing, the money claim, this is not status quo, preservation of status quo. This is a additional security. Then in that case, has to be a sacrosanct amount, undisputed amount. I am told, so Mr. Mukherjee said,
The order is to secure, for you to secure that amount.
yes.
Yes.
Lordship will kindly come to, firstly, no reason, that's a different matter. Lordship kindly comes to page 17 of the order. First, the firm doesn't have that money.
Yes.
Page 17, last paragraph. The partners themselves have been also. The only reason is the third last paragraph of 17, then 18, and then is the order.
Yes.
18, I mean, 17, third last, second last, and last paragraph. Respondents are directed to set apart rupees 6 crores in a separate interest-bearing account. Firm doesn't have the last balance sheet is on record. The only asset remaining is the property they are illegally sitting over which we have given notice. And to set apart, so it has to be begged, borrowed, and stolen money. That is an order which can be passed if there is an undisputed amount due. Show me the Sanghi Motors judgment, Lordship. There are judgments galore of our High Court, Shonji Banerjee judgment is there in Jai Balaji, but since now Supreme Court has said, which I'm told Mr. Mukherjee has placed before your
On which
on securing a amount claim in arbitration matter. Sanghi Industries. Very recent, 30th September 2022.
Yes.
This is section 9, 2E. Court doesn't have the power, certainly the arbitrator, like for further interim order as may be passed on that point. 9(2)(e).
Yes.
Paragraph 4. And paragraph 5. Having heard learned counsel appearing on behalf of the respective parties, and in the facts and circumstances of the case, more particularly when the bank guarantees were already invoked and the amounts under the respective guarantees were already paid by the bank much prior to the commercial court passed the order of section 9, and looking into the tenor of the order passed by the commercial court, it appears that the commercial court had passed the order and at 9(2)(e), such further orders, to secure the amount in dispute. We are of the opinion that unless and until preconditions of Order 38, Rule 5 of CPC are satisfied, and unless there are specific allegations with cogent material, and unless prima facie case, the court is satisfied that the disposing of the properties and in any other manner, the commercial court could not have passed such an order in exercise of powers under Section 9. Yes, there's a specific allegation with cogent materials unless prima facie case is made out. Then paragraph 5, the orders which may be passed by the commercial court in an application under Section 9 of the Arbitration Act is basically and mainly by way of interim measure. It may be true that in a given case, if all the conditions of Order 38, Rule 5 of the CPC are satisfied, and the commercial court is satisfied on the conduct of the opposite party opponent, that the opponent party is trying to sell its properties to defeat the award that may be passed, and or any other conduct on the part of the opposite party, opponent party, which may tantamount to any attempt on the part of the opposite party to defeat the award that may be passed in the arbitral proceeding. The commercial court may pass an appropriate order, including restraining and any other appropriate order to secure the interest of parties. However, unless and until the conditions mentioned in Order 38, Rule 5 are satisfied, such an order.
Mr. Mitro, the upshot of this would be that no interlocutory orders, no orders on a Section 9, because court would always go into the rival contention, see the documents, no flash orders to give relief.
Yes, but if that depends on facts. If the amount is undisputed, as has been said here, the amount is undisputed, then in that case, the court can certainly secure. Or let me show if you conjugate take it down. If the line at this paragraph 4, last 3 lines, at this stage it is required to be noted that even otherwise there are
that disputed questions.
it is very serious. Like here, the arbitrator himself noted, but status quo to be maintained, preserving the status quo. That's the order which the courts normally follow.
That's in 17 and 9.
That's
also.
17.
Yes.
Now, for mandatory order or for securing the amount, there has to be something more. Something more. Like there has to be absolutely amount is due and payable. This is the amount due and payable. This is also Lordship, see, this is even before the justice, before Supreme Court judgment. Even Lordship Jai Balaji Industries High Court, which is the one, this is Shonji Banerjee's judgment. And one can go even backwards and backwards and backwards, and it gets second page, 3rd paragraph. For a 3rd paragraph, 2nd page, for a claim which is essentially for an unliquidated amount, in damages, no order to the amount in nature of attachment before judgment is ordinarily passed. This is ordinarily passed. That's the whole point. It is not necessary to consider the petitioner's contention that the respondent has not dealt with the statements prior to entry. A strong prima facie case in support of the claim has first to be made out before the respondent's conduct can be gone into, or any allegation as to the respondent's impecuniosity can be taken into consideration. Here, the petitioner's claim is for unliquidated amount. Here also is the unliquidated amount. And I, of course, I'm putting my case very low because here it's admittedly applied 24(5). He has to contribute the money, as Mr. Mukherjee has shown, section 33. And he has got what his father had got. He can't, if his father entered into the partnership with this clause in the deed, that he has to contribute to the losses. The son and the widow and the wife by inheriting can't get more. However equitable or inequitable it may be. This is the inherited claim.
Yes.
So this has to be an undisputed amount. And justice, Lordship, the recent judgment, Lordship must have considered, this is Indira Banerjee's judgment in Supreme Court. There also, it was not
That was on the order 38 rule 5 principle.
Yes, SR. But there also I want to show yes. Paragraph
This was, I think, more on the 9.3 point.
9 E 9.3.
No, there was
Yes, this is on 9.3. This is 9.3.
whether the court can entertain
Yes,
and all that,
this is
application of mind.
absolutely. But there is a finding on para 48, wide powers of securing the amount dispute. So I wanted to just cover that part. There also her ladyship has said that a strong prima facie case has to be made out. That this is the amount due and payable. Short of that, for preserving status quo, just prima facie case is enough.
Which paragraph is that, Mr.?
Paragraph 48, 49, and 50. 50 may I place first? Proof. Para 50, this is what my lord said. This is a logical approach. I agree. Proof of actual attempts to deal with, remove, or dispose of property with a view to defeat or delay the realization of an impending arbitral award is not imperative for grant. I agree with it fully. That a strong possibility of diminution of assets would suffice. Strong possibility. To assess the balance of convenience, the court is required to examine and weigh the consequences of refusal of interim relief to the applicant for interim relief in case of success in the proceedings against the consequence of grant of an interim relief to the opponent in case the proceedings should ultimately fail.
So you're saying, Mr. Mitra, that there has to be some pleading somewhere that the asset is going to be wasted or frittered away?
That's, well, I don't have to put my case that high. I can see that this is the amount due and payable. First establish that. Or should we see the next paragraph, para 51?
Yes.
It is not in dispute that a sum of about rupees 35 crores odd was paid by SR Steel to SR House and 47 crores odd to SR Services, being the appellants in the respective appeals by way of security deposit, which is a refundable security. Prima facie, the refundable deposit is not being released to our seller on the purported ground of a convoluted series of internal arrangement between the group companies for diversion of security deposits towards liquidation of alleged dues of SR Steel to third parties. Here, the admitted amount, as the learned arbitrator has repeatedly recorded as also part of their submission, is 1 crore 28 lakhs minus.
Yes.
And as I've shown once at the 75th, at the 10th meeting, or that he has himself noted that. Then it's all becomes, may I borrow your phrase, eureka moments. I just suddenly feel that that this young man, he's 31, 32 years of age.
Without the exclamation, without the exclamation mark. Yes.
No, Lordship,
Yes.
in fact, we were before that, just a moment's digression. He was not there. We were before that arbitrator, learned arbitrator, and Shamrat Sen was on the other side.
This matter.
In another matter, just after Lordship's judgment. And my goodness, it was an open arbitration. There was a lot of discussion, and we all regaled ourselves at my lords, and which was being read out, and we on the other side we regale. And it so happened my solicitor was Fox and Mandal, so he was looking very accusingly at my solicitor also in the same matter.
Hopefully, the chairperson was not the arbitrator.
No, chairperson was not. And they were also having a very good time. The Judge Jyotirmoy Bhattacharya and Shubhra Kamal Mukherjee, but the other two arbitrators, they're having a very great time, and they were thoroughly enjoying my lord's judgment. So that those phrases have got really impressed on all of us present there. Now, Lordship, coming back to where we were. Mr. Mukherjee has already shown that in the petition, this case was nowhere. In fact, securing of where is the petition?
So, Mr. Mitra, your point is this: A, there has to be certainty as to the quantification, and B, once the quantification of a certain amount is there, there has to be some apprehension expressed in the pleadings that sum will be gone by the time if the petitioner does not get the relief.
As to and this to be so, and my first point is 24.5. This is contrary to 24.5. My last point I'm coming to is no reasons and based on service. Based on service.
Yes.
This is, Lordship will see in the what and why. What are the reasons that why has what and why test in Pata?
Yes.
Uniworth. That is applying that test, Lordship. What are here? Yes. 10.3 is what are the reasons? He has referred to section 24.5, which is in my favor. After noting their submissions from page 15, someone can't be left remediless. That has got nothing to do with the 6 crore. Why 6 crore? That is the only reason to be found is page 17. The arguments made by the claimant in the 12th sitting appear to have some substance. And he has totally ignored the arguments of Mr. Ghosh, copiously made and noted also from pages 10 to 13, from A to I. He has not dealt with any of the points, just not wholly without any basis. That is completely the most common judgment, Victoria Memorial case.
On the reasons.
On the reasons, Lordship, paras 31 to 33, that is the lifeblood of our judiciary. It's 31 to 33. to 33. A page our paragraph milchena. SCC Shangti paragraph bolo. Amari lekha ache. 40 paragraph 40.
Paragraph?
40. It is a settled legal proposition that not only an administrative, but also judicial order, but it's supported by reasons recorded in it. Thus, while deciding an issue, the court is bound to give reasons for its conclusion. It is the duty and obligation on the part of the court to record reasons while disposing of the case. The hallmark of an order and exercise of judicial power by a judicial forum is to disclose its reasons by itself, and giving of reasons has always been insisted upon as one of the fundamentals of sound administration of justice delivery system. The Arbitration Act contains it.
Yes.
To make known that there had been proper and due application of mind to the issue before
That's
the court.
fine. That's 31(3).
Yes. And now here, any order, any judicial order, and Lordship, one judgment on based on surmise. Okay, this is 16.5 CHN, page 625. This is a conjecture. This is based on conjecture. It doesn't, not wholly without basis. Falls far short of a security claim.
This is,
16.5 CHN 625.
no, that's fine. Which paragraph?
Para 26. Para 20. Para 20. Paragraph 20. Oh, paragraph 20, sorry. Paragraph 20, yes. In our view, before coming to the said conclusion, it was the duty of the appeal court to compare the certified copy of the said suit register with the original record. This has not been done by the learned first appellate court. We
Yes,
cannot
that's
agree with such findings as was arrived at. Yes, on the basis of surmise and conjecture.
That is all,
That is-
Mr. Mitra?
Well, I am not dealing with points which I apprehend they may raise, that they have relied upon the balance sheet. On the balance sheet basis, they have claimed this amount. They will say that the balance sheet, I don't accept it. In case they make those arguments, I'll have to respond with approbate, reprobate, and all those points. So now they wanted to come out of their own account, which was the basis of the account, which was the basis of the order.
Very well.
Okay.
Mr. Banerjee, when will you come back?
Either on 13th or on 19th, your ladyship, either of the 2 days, as it commenced to your ladyship.
The learned counsel for the petitioner, for the appellant, has concluded his submissions. Stop list this matter on 14th July 2023.
Your ladyship, 14th will be inconvenient for both me and Mr. Banerjee, who is leading me. So instead of that, could it be 13th?
Very well, 13th.
I'm deeply obliged, your ladyship.
Item number 12, Government of Maharashtra.
Your Lordship, we were supposed to file that.
Microphone, please.
We were supposed to file that affidavit. I just needed your leave, your Lordship, because it's been affirmed and signed by an advocate outside. If your Lordship wants, then we can put the back sheet and then file.
Yes,
Otherwise,
you have to do that.
usually what happens, because
Microphone, please.
advocate on record here has not signed that affidavit. The back sheets have not been filed. But I'll just get the stitching done and
Yes,
I'll just file.
you're representing the petitioner, the respondents.
Your Lordship, only one more thing. This was only with respect to the time of filing. These affidavits which were exchanged were only with respect to time. Whether I have filed within time or not. Not for
File
the-
what?
My petition, the under 34, whether it has been filed within time or not.
34(3). Yes.
So that is all that these affidavits are for.
So you're saying that you did not receive the award? What are you saying?
Your Lordship, I received a document. First of all, I'm Government of Maharashtra. Government of Maharashtra was not even made a party. I am not, that I will come in the substantive arguments. Till date, the Government of Maharashtra has not received a copy of the signed award. What has happened?
No, Government of Maharashtra is a party to the arbitration agreement.
No, your Lordship, a department, if it
Yes.
is a copy, so is party to a arbitration agreement or any agreement, under general laws of CPC and all, the government has to be made a party because the legal department is a government department. It has never been, it was never given a notice. No notice has ever been given to the government of Maharashtra. And they have proceeded with regard to a department which did not even exist.
Yes. Who is they?
Your Lordship, MSME Council. MSME Council proceeded with regard to a department which had, there was a directorate which had become a commissionerate, and till date, Your Lordship, we have not been given a copy. Now, why we have filed it, I will explain this thing. What happens is that they file an execution application.
Yes.
When they file that execution application also, Your Lordship, they file with a copy, their own copy of which was unsigned. An unsigned copy, which is not possible, that is not possible. And there is a judgment of the Supreme Court that the time to file a 34 also does not start till the parties have been given a copy of the signed award, or even a majority of the arbitrators if they have filed.
That's 34.3 and 31.5.
31.5. So that was not complied. We had taken that objection in the execution court. The government of Maharashtra took that objection in the 31 execution court before commercial court at Alipur. At that stage, what happened is apparently they filed some document with the Alipur court in sometime in April 2022. When and
Why the Alipur court?
because the commercial that is also very strange, Your Lordship. Because
Mr. Sinha, you can't wait for the court to ask you questions. You have to give the facts to the court.
yes, Your Lordship. The thing is, Alipur court, because Maharashtra Bhavan, there is a private property, unfortunately called Maharashtra Bhavan. They have attracted the jurisdiction of the Alipur Commercial Court by saying Maharashtra Bhavan belongs to government of Maharashtra, which is again not incorrect. We have taken that point also. That this is what has happened. And
Very well. Come to the service, please.
Yes. So then what happens is we have never got the service. We get to know from the court proceedings that when we are making the argument, they say that no, we have given a copy to the court. Your Lordship, then thereafter in November, the court directs them, Alipur court, and there is an order to that effect. They direct that we should be given a copy. We are given a copy. Now, there is a 2012 judgment which says service to even lawyers is not good.
Mr. Sinha, 34.3 says 3 months from the date of receipt of the award.
Yes.
Proviso says an additional 30 days. Are you coming within that
Yes,
or not?
yes. From the date when they served me in November 2022, I come within that period. There is no.
So they are saying that they served you before that.
They are saying that in 2019, when the original award was given, or purported award which was given, certified copy, that is service. That is service. That is what their thing is. And after that, they say in April, otherwise also, they apparently the MSME Council has sent the copy to the government of Maharashtra. That is what they say. But we have not received any such document. We have not received any such award. And that is why even the court in...
And you're not required to file the 75% deposit for a 34.
Your Lordship, I am with regard to that I would come to when...
No, first, without even going into the 34, I will have to see whether you have made that 75% deposit.
Yes, Your Lordship. With regard
That's
to...
19.
Yes.
Unless you're a supplier.
Yes, Your Lordship. The thing is, the award has been passed against somebody else. The execution has been filed against someone else. And the person who is challenging here is the government of Maharashtra.
Mr. Sinha, that's
I
34 argument.
Yes, yes.
Even before I get into that, I will have to see that you have complied with section 19
Your
of the
Lordship,
MSME Act.
Very well, Your Lordship. When Your Lordship will give me time, I will get the judgments which say if there is award itself is a nullity, then I don't have to go into this.
You don't have to pay 75%.
I will argue that I will not have to pay a 75% when the award itself is a nullity.
There's a judgment saying that.
I will argue from judgments.
Mr. Sinha, you can argue, but I am absolutely clear in this. If you are a supplier, you come within that exception. Because 19, I think, says not a supplier or something within brackets. If you are not, you have to pay the 75% and then only I will hear the 34. That's all.
Very well, your lordship.
Then whether you have, you're within 30 plus 3 months plus 30 days, all that is there. First 75%.
Your lordship. Your lordship will set, keep it any day, next week. I will try
Pay
to.
the 75%, I will hear it. Otherwise, I'm dismissing it today.
Your lordship, I have. to
I
take
will
instruction.
record your submission at best,
Your lordship.
that you will pay the 75%
Your
by,
lordship,
I will
have
give
to
you a
take-
date
I
and
have
then
to take-
only.
I have to take, your lordship, I have to take instructions.
There's no instructions. It's a statutory mandate on you.
Your lordship, may I just come back? If your lordship decides that yeah, I have to pay, we will have.
Or it's not my deciding.
Your
It's what the statute says, section 19.
Your lordship will then adjourn the matter.
MSME Act about the.
Your lordship, I am aware of the section 19. Your lordship will then.
You are only aware after the court made you aware.
Lordship,
Mr. Sinha,
I
you should have
I
said that.
indicate-
And I'm surprised that you did not take this point. You're the respondent. You
Your
could have
lordship,
taken this point first.
On the first day when it came up before.
If the court is not aware of the MSME Act provisions, then what? You will just keep quiet and not take this point.
Your lordship, we had all, no, your lordship, what happened is on the first occasion when the matter had come up in May, I had indicated this. The only reason why this was taken up was
In
This-
May, not before me.
not before.
Then
I had indicated on that day. And also your lordship, the reason why this is being taken up is there is the order which has been passed in this matter says that the chartered accountants and all, they will decide on the amount. The chartered accountants and all that they will decide on the amount.
Mr. Sinha, I have a judgment on that also.
Yes.
About this chartered accountant deciding, and I have said 75%.
Very well, your lordship, I will consider that.
No, you come back on Monday. If you don't pay, I'm dismissing this, because this matter, every time you come, either you will take a plea on some affidavit you have to file, or you will take a plea on some.
Your lordship will
There
keep
has
it on
been an
Tuesday.
extreme delay.
Your lordship will keep it on Tuesday. You will not-
Tuesday, 75% or dismissal. I'm recording in my order today. And don't make arguments which you have made before a coordinate bench, because that was not my court. So I am very clear on what section 19 mandates.
Very well.
The affidavit of service is not in form. What did you file today? Affidavit of service?
No, no. It is in, I will just, it is in the back sheet, the affidavit in reply, your lordship.
The affidavit in reply of the petitioner is not in form. Stop. The advocate on record is given leave to put it in the correct format. Stop. Next. In any event, comma, before the section 34 application is even considered, comma, the petitioner being the buyer in the transaction, within brackets, and not the supplier, close brackets, under the provisions of the MSMED Act 2006, comma, is required to pay 75% of the decretal amount of the awarded amount before the case, before the court entertains the application. Stop. This is the clear mandate of section 19 of the MSME Act 2006. Stop. Next learned counsel for the petitioner seeks an adjournment to take instructions on this point. Stop. Next. This court is of the view that there is nothing to take instructions since the statutory mandate is clear. Stop. Section 19 specifically mentions quotation marks setting aside ... of any award ... close quotation marks. Stop. Hence, the petitioner must put in 75% of the awarded amount by within the returnable date. Stop. If the petitioner does not, comma, the arbitration petition will be dismissed on the next date. Stop. Much time has already gone by, and the petitioner, and this preliminary point was not taken by either of the learned counsel appearing before the court. And this preliminary point, surprisingly, was not taken by either of the learned counsel appearing before the court. Stop. Next, this is matter when
Your lordship, Wednesday, Tuesday.
75%, otherwise dismissal.
Wednesday-
This is matter on 12 July 2023 as prayed for.
Your lordship, one more thing. There is a writ petition on the same matter Writ petition being WP number 10653 of 2020. This was filed beforehand because at that point of time, we did not have the signed.
How is this court concerned about a writ petition?
Your Lordship, because there are judgments of this court where if the rules of natural justice have not been followed, orders and awards of the MSME Council have been set aside.
Mr. Sinha, one more vexatious submission, I'm going to impose costs on you as counsel. Do I have the determination to hear the writ
No, no,
petition?
Your Lordship,
Then
I was just saying that that could be taken up, then I will get it assigned. That is why.
why will you get it assigned before this court?
Because it's on the same subject matter, Your Lordship, on the same matter.
Yes. Counsel persists in making all kinds of vexatious submissions with regard to a writ petition filed by the petitioner, allegedly on the same cause of action. Stop. This court finds no merit in such submission. This court in any event does not have determination to hear the writ petition and does not wish to have the matter assigned as has been submitted by counsel. Stop. Next.
The petitioner, my lord.
You have to wait for the matter to be called on, Mr. Chatterjee.
Lord said next or so.
Item number 13, he'll take electronics.
For the petitioner, my lord, there is a possibility of settlement, my lord. The parties and I was praying if it could stand over the matter for 2 weeks. And my lord, in spite of an extension, my lord, we are not in a position to file our reply. I'll forego my right to file a reply. My lord was.
Lordship, I am appearing for the
Settlement.
Yes, your Lordship.
Yes, learned counsel appearing for the petitioner submits that the parties are exploring a settlement out of court. Stop. Please this matter when?
Well, 2 weeks, my lord, if you may stand.
2
over.
weeks is prayed for.
I'm grateful, my lord.
Grateful, your Lordship.
Next.
14, Cholamandalam investment.
That matter also will, my lord, settled between the parties.
What is happening? Everybody settling matters in this court.
Lord,
What is happening?
Lord, I'm appearing for the petitioner in this matter.
Yes,
Lord, there has been a settlement between the parties by virtue of which the respondent is supposed to pay a sum of rupees 8 lakhs in 4 installments. They have cleared the first installments in the month of June. The next installment is scheduled on July 20th. Lord, I was humbly praying if this matter can be kept in the last week of this month, my lord. In the event they pay the next installment,
yes,
we withdraw this
learned
matter.
counsel appearing for the petitioner submits that the respondent, that the parties have entered into a settlement whereby the respondent is to pay the amount in 4 installments, the first of which has already been paid, and the second is due to be paid on 20th July 2023. Stop. Council accordingly seeks an adjournment and prays that the matter be listed in the last week of July. Stop. List this matter on, give me a date, please, last week.
Any day convenient, your lordships.
List this matter on 27 July 2023 as prayed for.
I'm grateful.
the affidavit in opposition be kept on the record.
The affidavit in opposition is taken on record.
If the affidavit on reply may be also taken on
The
record.
affidavits of opposition and reply are taken on record. Next.
Respondent.
15, Cholamandalam investment.
I'm for the petitioner, my lord, in this matter. But if your lordship recalls, your lordships have heard this matter extensively. On the first date, my lord, your lordships had categorically recorded that the Section 9 petition is maintainable. Thereafter, your lordships had posted this matter on the next date, my lord, whereby, my lord, the respondents were directed to, my lord, indicate as to why security should not be furnished.
Is the board not working outside? Will somebody please go and find out if the board is working? And is the display board working or not that too? Yes, yes, Mr. Sharkar.
But on the last, my lord, on 12th of June, my lord, your lordships was, my lord, pleased to, my lord,
Not 12th, 13th.
12th of June, my lord, your lordships had pointed out, my lord, lordships are categorically held, my lord, that the Section 9 petition is maintainable. We sought for, my lord, security, my lord, upon establishing that there is a prima facie case of default. On the last occasion, my lord, the respondent appeared And they made a submission that they dispute the amount that is due and outstanding. And they sought to file an affidavit in opposition. In the affidavit in opposition, not a single averment or allegation is made as to what is the amount which, according to them, is due and payable. Nothing has been annexed, nothing has been relied upon. Lord, we have also filed an affidavit in reply, my lord, in response to the allegations that has been made by them, my lord. Today, I'm only praying, my lord, what fell from your lordships on the last day, that a security be, my lord, furnished in terms of prayer A of my petition, because the debt is undisputed. And neither have they pointed out what, according to them, is the amount which is due and payable.
Lord, I'm for the respondents one.
Yes, for
May I
your
please your
response.
lordships?
Yes,
My lord, I have filed my affidavit in opposition, my lord, whereby I have said that the amount is disputed.
this is a 9.
My lord, this is
section
a section 9
nine.
application.
Section 9. Yes.
My lord, so in my affidavit in opposition, my lord, I have stated that the account is that the amount which they have claimed is, my lord, disputed.
Yes.
And my lord, I had wished to rely upon the statement of account. Now, my lord, in my to my affidavit in opposition, my lord, they have filed a reply, whereby, my lord, they have brought on record, my lord, the statement of account. My lord, if your lordships, my lord, kindly, my lord, sees the statement of account, my lord, your lordships will find that the declaration of the loan account as NPA is itself, my lord, bad. My lord, my loan account could not have been declared as an NPA on the date on which they have declared it as an NPA. My lord, according to the RBI guidelines, if I may, my lord, I'll refer to that, my lord. But just before that, my lord, I'll just
That's on the merits. Why should
Yes,
we not
so-
secure the amount?
my lord, may I indicate? If, my lord, my loan account would not have been declared as NPA at that time, they could not have, my lord, terminated the
Have you filed
contract.
your reply?
My lord, they have filed their reply.
Yes.
They have filed their reply.
Yes.
My lord, if
May I be
the
permitted to file the affidavit
Lord,
and reply
if-
before this?
may I
Or
also, my
the
lord, be
lordships
permitted
leave?
to, my lord, file my affidavit?
Yes,
in
the affidavits in opposition and reply are taken on record. Yes.
Lord, if the loan account itself, my lord, could not have been termed as an NPA on that day, which would basically go to show that the loan account was a live account at that time. So, my lord,
What do you
if
mean could not, there are some RBI
yes,
guidelines and
my lord,
norms.
I'll refer to that. My lord, the RBI income.
2.0,
Yes,
whatever, yes.
I'm so grateful to your lordships, my lord. Income recognition on prudential norms guidelines, which I'm referring to, my lord.
Yes.
My lord, that guideline essentially says that, my lord, in case of a term loan, and this is essentially, my lord, a term loan, because this is a business loan. So, my lord, in a case where it is a term loan, my lord, if the principal installment remains overdue for more than 90 days, only in that circumstance can, my lord, an account be termed as an NPA. My lord, I'll establish before your lordships that on the day on which I have first, my lord, could not, my lord, repay the amount, on that day itself, my lord, they have declared the account as an NPA. So basically, my lord, on that day, they have also terminated the contract. So, my lord, on that day, if they have terminated the contract, the amount which was due and payable, according to them, is, my lord, never due and payable to, according to us. Because, my lord, on that day, the account was still a running account. So, my lord, this is basically one of my primary defense, my lord, which I am relying upon. And, my lord, may I formally, my lord, rely upon the RBI guidelines? I'm carrying copies, my lord.
Yes. Just formulate your points and then that is the only point of.
No, my lord,
defense.
I have one more point.
Yes.
Well, may I, if I may say the second point also. my lord.
Yes, yes, of course.
With regards to the second, my lord, I'm relying upon the judgment of the SR, my lord, which has been laid down by Honorable Justice Indira Banerjee. My lord, in which
No, that's on the order 38 Rule 5 principle.
yes, my lord, which says that, my lord, the specific apprehension with regards to diminution of properties is not necessary. However, my lord, it's a mere possibility of, my lord, dealing away with properties has to be, my lord, established by my learned friends. However, my lord, I'll indicate before your lordship that there is no, even, my lord, no remotest of possibility of, my lord, any, my lord, disposition of any properties.
Why do you
whatsoever.
say so?
My lord, because, my lord, they have, my lord, in their petition, my lord, stated two properties. One is, my lord, one property which they have stated of one address, that is not my property. That is my father's property. That's an undivided property, my lord. So, my lord, that is in any event, my lord, cannot be, my lord, disposed by me. And they have referred to one car, my lord. I did not have that car from, my lord, way long back. And, my lord, it didn't even was in possession of me. So, my lord, these were the two properties which they indicated. They have indicated one more account, my lord, the savings account. The savings account has been closed long back.
Who are you? PG Fish Center.
Yes, my lord. My lord, I'm
What
PG.
is the business?
My lord, this was basically a business of, my lord, preservation and storage of fish items. Now, my lord, what, my lord, due to some, my
Don't
lord,
say fish items, fish.
my lord, fishes, yes, my
Yes.
lord, fish. I'm so sorry, my lord, that's fish. Now, my lord, of course, my lord, the business didn't run well, so my lord, we defaulted. My lord, that's correct. But my lord, the NPA, my lord, which they say, as I have already mentioned before, your lordships, my lord, that is wholly incorrect. My lord, the account could not have, because my lord, at that time, the account was absolutely a running account. My lord, I'll indicate that before your lordships. May I, my lord, formally first place the RBI guidelines, my lord.
Just 1 or 2 pages, more or
Yes.
I'm more or
I'll
less.
just indicate one paragraph of it, my lord.
This is 6th August,
This is-
2020.
My lord, I am in my hand, my lord, I'm having the 1st October 2021. It's always renewed, my lord, every year. So, my lord, I'll just if for you. Thank you.
How much time will you take today, Mr.
My lord, I'll not.
You're Mr. Basure?
No, my lord, I'm Snehashish Chakraborty.
Sorry,
Yes, my
Mr. Chakraborty. How much time will you take?
lord, I'll not take more than 15 minutes, my lord.
No, can't give you that.
My lord, I'll
Just
cover.
5 minutes, formulate your
Sure,
points.
sure,
please.
my lord. I'll just take 5 minutes, but I'll not take more than that, my lord. My lord, if your lordship, my lord, take page 5 of this, my lord, guidelines, my lord.
Yes, just 5 minutes, please, today.
Yes, my lord.
Yes.
My lord, non-performing asset, 2.1.2, my lord, I'm just relying upon the first point. My lord,
Yes.
non-performing asset is a loan or advance where interest and or installment of principal remains overdue for a period of more than 90 days in respect of a term loan. My lord, I am trying to restrict myself within this point because my lord, my case is it's only with regards to a term loan. Now, my lord, keeping this in hand, if I may, my lord, invite your lordship's attention to their reply.
Yes. So you're saying the date on which it becomes overdue plus 90 days.
Yes, my lord. Yes, I'm so grateful, my lord.
Yes.
My lord, if your lordships may come to, my lord, straight away, my lord, to page 11 of their reply.
Yes.
My lord, your lordships will find a list. My lord, my lord, at the right-hand corner of the list, my lord, your lordships will find last NPA date. That's, my lord, the starting page of, my lord, the statement of account. My lord,
Yes.
your lordships will
Where do you find it?
my lord, page 11 at the right-hand corner, my lord, there is one list which is
Yes.
given. My lord, the penultimate, my lord, point, last NPA date. My lord, right after asset classification. Your lordships will find, my lord, asset classification as non-performing asset. After that, my lord,
Yes, yes.
my lord, that's, my lord, the last NPA date is 5th March 2023.
Yes.
Now, my lord, kindly sees, my lord, just, my lord, beside that on the left-hand corner is the delinquent date. That's also the same day, my lord, which is 5th March 2023.
Yes.
Now, my lord, with that, may I, my lord, first show your lordship, my lord, I'm grateful to my learned friend, my lord, they have, in fact, my lord, showed, they have, my lord, prepared a chart whereby they have showed, my lord, from which day I have, my lord, first, my lord, could not repay, my lord, my amount. My lord, that's your lordships will find at, my lord, page 17.
17.
17, my lord.
Yes.
My lord, kindly sees number 9, my lord. That's the first day on which I, my lord, could not repay insufficient funds. That's on 5th March 2023.
Yes.
So, my lord, from that very day, if, my lord, the NPA starts counting, then, my lord, March to April, April to May, and May to June. So, my lord, on the 6th of June, my lord, at best, my learned friend could have, my lord, declared the loan account as an NPA.
Yes.
And from that very day, my lord, their right to sue accrues, my lord, against me. Not before that, according to, my lord, the RBI guidelines. So, my lord, this is my first point. And, my lord, kindly sees one more, my lord, aspect. The amount, my lord, which they have claimed. My lord, if your lordship may take, my lord, page 5 of their reply.
Yes.
My lord, kindly sees para G.
Yes.
My lord, it's 16,20,326 calculated up to 12th of April 2023. So, my lord, the outstanding which they are claiming at the period at which, my lord, they are claiming the outstanding, at that period, my account was perfectly, my lord, a live account. And it was a normal account, my lord, because, my lord, at that time, the loan account couldn't have been, my lord, declared to be as an NPA. So, my lord, this is my first point. Now, my lord, may I, my lord, my lord, come to the second point.
Mr. Chakraborty,
Yes.
come back on some other day, please. Tell me when, next year, next.
My lord,
week,
next
sorry.
week, any day as your lordship feels convenient, my lord.
Learned counsel opinion for the respondent takes the first defense to the claim for security on the ground that the respondent's account could only have been declared NPA on 6th June 2020, 2023, calculated on account of 90 days from 5th March 2023, which was the last NPA date recorded in a loan account information document as on 22nd June 2023. Stop. Council relies on clause 2.1.2A, 2.1.2 এটা কেটে দাও, of the RBI Master Circular of 1st October 2021. Stop. 2.1.2 within brackets choto I. 2.1.2 within brackets choto I. Next, council has other points which will be heard, which will be argued and heard on 14th July 2023.
I'm deeply obliged, my lord.
Grateful, my
Call on the next matter, please.
Grateful, my lord.
No.
Item number 16, Primac Tirumala projects.
This is my appeal under section 37 of the Arbitration Concession Act. My lord, your lordship had taken up this matter on 16th of June. My lord, your lordship, my other side had taken directions for affidavit.
Other side, the last
My
order.
lord, yes, my lord, may I just hand over a copy?
I have it. Yes, affidavits.
Yes, my lord, will kindly come to page 2, my lord. My lord, the penultimate paragraph, my lord, affidavit option filed within 2 weeks.
Yes.
My lord, but no affidavits have been forthcoming, my lord. So, my lord, if your lordship,
2 weeks, it's gone. Yes. No one appears for the respondents.
no one is appearing, my lord.
Stop.
Oh, sorry.
The respondents have been directed to file their affidavit in opposition by 2 weeks from the last order dated 16th June 2023. Stop. Learned counsel appearing for the petitioner is requested to communicate this order on the respondents, and particularly that the respondents will have a last opportunity to file their affidavit in opposition by 14th July 2023. Stop. List this matter on 18 July 2023.
Reply in the meantime, my lord, if your lordship can transmit that one.
But will you be able to, if you get it on 14th, will you be able to give your reply?
And then could you, if your lordship will please to fix it on 22nd, my lord, if it's possible.
List this matter on 22nd is a Saturday.
No,
On 24th July 2023 as prayed for. Stop, reply in the meantime.
I'm very grateful to your lordship.
Seventeen, the Hooghly Mills Company Limited.
My lord, in this application, I appear for the respondents.
My lord, I appear for the
I
petition.
appear for the respondents, your
This
lordship.
is a section.
Section 37, my lord, appeal, my lord.
37. Yes.
My lord, pursuant to the last order, we had sought for your lordship's leave to file certain documents. in the form of a
You're
paper.
the respondent.
I'm
in
for
the
the
appeal.
respondent, your lordship.
Yes.
So may I file those documents? I have served my learned senior friend.
By way of a supplementary affidavit.
My lord,
Lordship
paper
permitted
book.
them to file, my lord, in the form of a compilation.
Compilation, my lord, paper book.
These are records of the, my lord, arbitral
Volumes.
proceedings.
So you have challenged section 17 order, Mr.
My lord,
Doctor?
yes, my lord, I have challenged, my lord, the order of 3rd of September 2022 passed by the learned arbitrator, my lord, on an application filed by the respondent, praying for stay of all further proceedings in the arbitration proceeding. My lord, this is in connection with, my
And the
lord,
respondent is a claimant.
no, respondent is also the respondent in the, my lord.
You are the claimant.
I am the claimant, my lord. Well, I'll
Yes.
briefly, my lord, indicate the facts. My lord, this pertains to, my lord, there are two references which were going on. It pertains to, my lord, two, my lord, commercial units at, my lord, E-Mall in Central Avenue. Unit number 1 and 2. My lord, in respect of each unit, there are 3 agreements. One is, my lord, the leave and license agreement. Other is, my lord, facility agreement. And the third is a maintenance agreement. Now, so far as, my lord, the leave and license agreement is concerned, my lord, that is in respect of, my lord, the respondent and another entity, Hooghly Investments Limited. Now, my lord, disputes had arisen between the parties. It was, my lord, we had invoked the arbitration, my lord, clause contained in the leave and license agreement. And, my lord, we were referred to the arbitrator. My lord, the arbitrator, after hearing, my lord, passed an award, my lord, directing eviction. Now, my lord, that award was challenged by the respondent before this honorable court. And in course of hearing of the section 34, there was a section 36 to application filed, based on which, my lord, a particular amount was ascertained as an interim, my lord, amount which would be paid to me for the purpose of stay of operation of the award. That is, my lord, subsisting. Now, based on that challenge, in the section 34 application, the other references pertaining to the facility agreement and the maintenance agreement, my lord, there, my lord, the respondent files an application saying that the principal issue is that whether I am liable to be evicted or not, which has been decided by the other award, which is under challenge before this court in a section 34. Therefore, you cannot continue with this proceeding and please stay all further proceedings in this reference. This is, my lord, the subject matter of the, my lord, present application. I am, before your lordship, challenging that order. Now, my lord, threefold, my lord, grounds which I have, my lord, urged, my lord. First is, my lord, the act does not, my lord, permit or, my lord, provide an enabling provision for the arbitrator to stay proceedings. There is no such provision, my lord, subject to
In a
the-
17.
in, my lord, the in by way of a 17 or, my lord, any other provision. There is no, my lord, mechanism for the arbitrator.
What it provides for is termination of the arbitration proceedings.
Absolutely, my lord. It is only, my lord, by reason of 32, the, my lord, modalities are there.
And that is only by way of when an award is pronounced.
Or parties settle,
Or-
my lord.
Yes.
Those are the, my lord, for modalities on which, my lord, it can be terminated.
Yes.
Now, my lord, the question before your lordship would be whether, my lord, the arbitrator had at all, my lord, the jurisdiction to entertain this application first. My lord, second, my lord, whether in the facts of the present case, my lord,
Section 11 appointment.
Section 11 appointment. So, my lord, there are actually, my lord, there were 6 references. 2 had culminated into the award of eviction and 4 were pending before the arbitrator. In these 4 matters, my lord, 4 applications were filed.
You had wanted the respondent's eviction.
I had wanted the respondent's eviction from those commercial units. So, my lord, on these 4 applications, the learned arbitrator, by the order under challenge, my lord, has, my lord, stayed all the references. Now, my lord, the other aspect of the matter is, my lord, we understand, my lord, the section 34 challenge might take some time, my lord, to be ultimately decided. Then there is a recourse available under the act, my lord, under 37. Then, my lord, that can also be challenged. My lord, if this, my lord, continues for a while, my lord, that would not, my lord, necessarily mean that the arbitration proceedings shall remain stayed. And, my lord, lordship will also consider the applicability of section 29A here. My lord, the statute mandates that once, my lord, the reference, my lord, the arbitrator enters upon reference, my lord, there is a timeline, my lord, provided.
No. That was 29A pre-amendment. Post-amendment is after completion of pleadings.
Yes.
1 year from
6
the
months, my lord, for
completion.
completion of the pleadings, my lord.
Pre-amendment was entering reference.
Yes, my lord. So I stand corrected, my lord. Lordship is absolutely correct. 23(4), my lord, gives the period, my lord, 6 months for completion of pleadings.
29A3.
A3.
29A1, 1 year. 29A3, 6 months. 29A4, court.
So, my lord, that period, even if that period is over, my lord, whether the arbitrator would still have mandate
Yes.
continue with the proceeding. That would be another ground lordship has to consider. My lord, in the facts of this present case, my lord, I find that on the date when the my lord arbitrator passed this order, my lord, his mandate, my lord, possibly stood terminated because of the operation, my lord, efflux of time, my lord. And although my lord, both parties by conduct, my lord, continued before him because this application was being heard. So that would be another
So
aspect.
that
lordship
would be
consider.
a ground under section 14.
That would be a ground under section 14, but my lord, while considering the 37 appeal, on the aspect of jurisdiction, this issue might also come up whether the arbitrator on that day, whether he had the jurisdiction or not. But I would
So
really
that does not amount to, sorry, Mr. Dutta, I'm
No, my lord,
interrupting
kindly.
you. That would not amount to a de jure or a de facto inability.
That would, but I would, my lord, we are in the process of filing applications, my lord, seeking, my lord, extension of the mandate, because 29(4) is now we have to invoke that, my lord, and come before your lordship. The consent part is also over. So that will come up in its usual course. So I would
But
really
a more
not.
interesting point is, I will of course have to look with whatever you're arguing, but the more interesting point is whether the arbitration can be stayed under any provisions of the act, subject to, of course, hearing your learned.
And factually, my lord, here, when the my lord other proceedings were out of the my lord leave and license agreement, that reference was, my lord, continuing. A similar nature of application was filed by the respondent staying for further proceedings in these, my lord, arbitrations, 4 arbitrations. Now there the learned arbitrator passed an order, my lord, saying that he would proceed till such time the award is published in the eviction proceeding. Now he, my lord, that also will, my lord, arise for consideration whether, my lord, he can recall his own order or modify his own order by saying, no, now I will not hear the arbitration reference till such time the issue arising out of the leave and license agreement as to, my lord, the eviction matter, whether till such
Show
time.
me, I need to see the name of the arbitrator. Which page would I find it?
My lord, if your lordship is looking at the petition, kindly takes, my lord, page 29, my lord. This is the, my lord, order which has been passed,
Yes,
and
yes.
lordship will
Yes.
find the name there, my lord.
That's I've seen it. Yes.
Yes. My lord, may I start placing the order, my lord, first, my lord?
Mr. Dotto, just formulate your points. Come back on in the next week, please.
My lord, so threefold, my lord, points. First is, my lord, jurisdiction.
Yes.
Second is, my lord, maintainability of the application, because, my lord, I say there is no enabling provision in the act for a party to apply before the arbitrator seeking stay of proceedings. Third is, my lord, applicability of the provisions of the act itself, which requires an arbitrator to, my lord.
So you're saying that the mandate terminated by the time the section 17 was entertained?
My lord, by the time this, yes, my lord, but we, both of us, my lord, we continued. We were also under the impression that he had the, my lord, mandate. So lordship, there, my lord, since I'm coming up with the other application, I will not urge that issues so, my lord, exhaustively. But more, my lord, important point would be, my lord, the jurisdiction of the arbitrator and right of a party to the proceeding to apply for stay. That would be my principal argument for your lordship. My lord, I can come back any day, my lord, lordship wants next week, my lord. By that time, my lord, those applications would also come up, lordship can take up all together.
Which applications?
My lord, I am in the process of filing applications under 29A4. My lord, I would be, my lord, seeking, my lord, orders, my lord, for your lordship to, my lord, extend the mandate. If lordship
so then you're stopped. You're stopped from
I know, my lord, I will-
arguing the point under 29.
I will not argue. That is the reason why I say, my lord, I will not argue that point here, my lord.
Or I can say that your application is dismissed now.
Lordship can definitely say that, my lord, but I would like to, my lord, impress upon your lordship that lordship need not go thus far. And I would try and convince your lordship that.
Very well. Tell me when you want to come.
My lord, next week, my lord, any day except, my lord, my lord, Tuesday, my lord. Any
17th.
Day.
17th. Or you can come back on 14th, actually.
My lord, I can come back on 14th if lordship.
Yes. This is an appeal arising out of an order dated 3rd September 2022, passed by a learned sole arbitrator in an application of the respondent filed under section 17 of the 1996 Act. Stop. The respondent is also the respondent in the arbitration. Stop. Next, learned counsel appearing for the petitioner has made his preliminary submissions. Stop. Lists this matter on 14th July 2023 for counsel to continue with his submissions.
Grateful.
My lord, may I seek one indulgence, your lordship? May I file the paper books, your lordship, as per your lordship's order?
We have been
Compilations.
Yes, the compilation of documents filed on behalf of the respondent is taken on record. The compilations of documents are taken on record. Next.
I'm grateful, my lord.
My lord, the same order can be passed in the.
Let the matter be called on, please. Yes,
Item 18.
I've been led by Mr. Subhash.
yes, same order. না তাহলে এখানে কম্পিলেশনটা ওই লাইনটা কেটে দাও। নেক্সট।
Item number 19.
My lord, same, my lord.
সেম অর্ডার কম্পিলেশন
Compilation
লাইনটা কেটে
part.
দাও।
Yes.
Item 20.
And that is also my lord, same.
Same, my lord.
সেম অর্ডার।
Grateful, my lord.
I'm grateful, my lord.
Yes, before I take up the examination of judgment debtors, any matters which council are waiting for and are urgent?
Item number 22, my lord, which is the setting aside, Mr. Siddhartha Lahiri was arguing, your lordship had kept in your lordship's list because of the direction of the Supreme Court.
22.
Yes, ma'am.
The petitioner is here.
I don't see Mr. Lahiri in court, my lord, in your lordship.
Very well. 21 টা ডাকো তো।
21, the Orient and Insurance.
I appeal for the petition. It's an application for setting aside. It's an application for setting aside of an amendment.
Yes. Mr. Huda, you're for the respondent?
For the response.
Mr. Gupta, tell me when I will keep the matter.
Lord, next week, any day. my lord.
Take the order ছিল। I've already heard you.
Yes.
Yes, list this matter on 13th July 2023. Next.
22, Union of India, General Manager, Southeastern Railway.
Take the last order. So, Mr. Sen, you were also to file a short note.
Your lordship had directed not the petitioner to give us a short note. What they have given us is a letter giving a list of the judgments they will rely on, no short note.
No, that was to be filed to the in court. There was no direction to file it, to give it to you. No one appears for the petitioner. Stop. The learned counsel appearing for the respondent submits that contrary to the direction passed on 21st June 2023, the learned counsel appearing for the petitioner has handed up a list of citations to counsel for the respondent.
It is in this form.
Stop. It in any event, nothing has been filed in court as directed on the last occasion. Stop. Next, nothing to no document has been filed in court as directed on the last occasion. Stop. Next, it may be recalled that when is the Supreme Court thing? What is the date? Have you got a copy of that, Mr. Sen?
If we had filed a compilation in your lordship.
No, that there was a time limit within which the court was to.
6 months from 14th February, 28th February, 6 months. Compilation of documents.
Yes, yes, I have it.
6 months from 28th February. What are 20th February, there is 6 months.
Yes, it may be recalled that
My lord, Siddhartha lady is coming. My lord, Siddhartha lady is appearing for the railways. My lord, he's coming.
he's coming.
Just 5 minutes.
That the Supreme Court had given a direction on 20th February 2023 to decide the Section 34 matters within 6 months from the date of the order. Stop. No one appears for the respondent or caterer. Adjournment is sought for on behalf of learned counsel appearing for the petitioner. Stop. Next. List this matter on, when do you want to come back, Mr. Lahiri? List this matter on 11th July 2023. That is all right, Mr. Sen?
Yes.
Yes, any other matters where counsel are waiting? Yes, examination judgment debtors.
Examination of judgment debtors, item number 91, C Doctor and Company.
So I appear for the decree holder.
Yes,
The judgment debtors chartered accountant was in the box, my lord.
yes.
We had called upon him to produce certain documents.
he has
Those documents have not been produced. So, my lord, there was a direction by court. There was a direction by court, my lord,
Yes.
unless these documents are produced,
Direction-
somebody else will be present. In the event the documents are produced, the same gentleman would be required to be present for further examination. The order is of 21st of April, 2023. Well, I've been informed that the gentleman has expired.
He has passed away, so Millard, he can't be present anymore. On 22nd June, Millard, he has passed away, Millard.
So what do you propose to do, Mr.
Millard, kindly, Millard,
Ghosh?
keeps it on 28th, Millard. I'll
Well, he has to
bring
give the documents.
I'll give the documents in the 22nd June. It happened, Millard. 28th Lordship keeps it subject to.
So that is Mr. Nishant Kumar,
Yes,
He has passed away, Millard. He has 30. He got drowned, Millard, and died
drowned.
in the
Drowned
swimming
where?
pool. Swimming pool, Millard.
I shouldn't be saying this, well, let them produce
I
the
have-
death certificate and put it on record.
I have the email with me. If you
Because
want, someone has died. If
No,
you
no,
want,
no, I will direct that. That has to be on record anyway.
yes.
Learned counsel appearing for the award debtor. It's a award debtor or judgment
debtor.
award
debtor,
debtor
Lordship.
submits that Mr. Nishant Kumar, dekhe nebe order, who had deposed before the coordinate bench on 21st April 2023, passed away on
22nd June, Millard.
22nd June 2023. Stop. Next. Council seeks an adjournment on this basis. Stop. Next. The award debtor shall file the certificate of death on the next occasion and give a copy of the same to the petitioner, to the award holder. Stop. The direction on the award, the direction passed by the coordinate bench on the deponent to provide statements of
So these are bank accounts, my lord.
bank accounts,
And my lord.
statements of bank accounts for the last of the last 2 years shall also be complied with within the returnable date. Stop. Next, list this matter. When do you want it? 28th.
28th.
List this matter on 28th July 2023 as prayed for. Stop. The details of the accounts, comma, as was directed on 21st April 2023, comma, shall be furnished to the award holder by, give me a date, please, Mr. Ghosh.
The week before that, I'll give Millard, which is 21st, I believe.
By 21st July 2023.
But there was also a direction for them to furnish me documents from which it would be evident the source of income of 2 crores of the company, and my lord, how
Whatever is
and
there,
the-
my lord, I have to comply with.
well, the order provides for that.
Yes, the other direction with regard to the income of 2 crores, which was recorded in the order of 21st April 2023, shall also be complied with by 21st July 2020.
And the issue of jurisdiction, my lord, was directed to be heard. I give the papers. Lordship will hear me on jurisdiction.
Very well. Yes.
Great.
I'm great.
Great.
Really sorry, my lord, 22, I could not come, I was rushing.
Yes, call on the next matter, please.
92 action. 93, Kotak Mahindra.
Lordship, this is my execution application. There was a warrant of arrest against the judgment letter number 2 on by an order dated 24th March 2023. Lordship, the sheriff has to file his report.
In 1950. That's from we the check your because we have to do this.
Sheriff কি আছে এখানে? Yes, the deputy sheriff is not present in court. Stop. It is not clear whether the order passed by a learned single judge on 24th March 2023 has been complied with to the extent of the SP of police filing a report on the reason for non-implementation of the warrant of arrest. Stop. Next, list this matter. When do you want to come back?
Lordship, after a week or when?
List this matter on 21st July 2023. Stop. The order dated 24th March 2023 must be complied by 14th July 2023. Next.
94, Kotak Mahindra.
Lordship, in this matter also, there was a warrant of arrest by an order dated 24th March 2023.
Same order. Next.
95, Mickey Metals.
You're for the petitioner? No one appears for the parties? Stop. List this matter on 14th July 2023. 14 or 21st.
96, Kotak Mahindra.
Lordship, this is my execution application. Lordship, by an order dated 12th, there was a direction upon the judgment debtors to file their affidavit of assets.
Yes.
Lordship, the affidavit of assets had been filed, but it was not supported by documents. Thereafter, there has been orders given to them to give the supportive document. The last order was passed on 12th May 2023, Lordship, by which they were asked to give the related documents to their income tax return. Lordship, what has been given to me is an income tax return acknowledgement, where the judgment debtor number 1, who is a company, its income is being shown as 0. There is no balance sheets given to that, even for the judgment debtor.
Yes, what do you have to say?
Lordship, on the last occasion, Lordship has directed to provide the documents related to income tax department.
Not this
Income-
court, the
Lordship,
learned single
Lordship.
judge. Yes.
Lordship, I have provided the documents, is the affidavit.
Income tax returns of the
Lordship.
judgment debtors.
Lordship.
Have you not done that?
Lordship,
Where are the
Lordship,
documents?
it's the IT acknowledgement receipt only, not balance sheets. It's a company. The judgment debtor number 1 is a company, and the income is being shown as 0.
So what do you want? Ms.
Lordship, the balance sheets, the
Lordship,
last
on the-
5 years balance sheet has to be given. Thereafter, there has been certain bank accounts which has been mentioned in the affidavit of assets of all the judgment debtors. No supportive bank statements have been given to that.
Yes, the affidavit handed up on behalf of the award debtor shows a series of income tax return acknowledgements, but not documents which would show the position of assets of the award debtors. Stop. The award debtors are hence required to furnish the balance sheets for the last 5 years, as well as particulars of the bank accounts mentioned in the acknowledgements by way of an additional affidavit, which is to be filed by
Lordship, the judgment debtor lives in Maharashtra. Lordship, kindly give me 4 weeks time. Kindly, because on the last occasion, the judgment debtor came.
by 4th August 2023.
Grateful, Lordship.
Stop. List this matter on 11th August 2023. Next.
Grateful, Lordship.
As paid for Koda, 4th August as paid. Next.
97 Poonawalla housing.
In this matter, Madam, I'm appearing on behalf of award holder. In this matter, the warrant has been issued against the award debtors. That is pending. But last occasion, we have also matter has been adjourned. We are taking instruction from client in this matter. What happened? The management is changing. The company has to go on to some other part. I'm awaiting for instruction and adjourn for 6 weeks. In the meantime, I think everything will be fine. I'm playing simple adjournment for 6 weeks.
Yes. The advocate on record, the petitioner seeks an adjournment on the ground of the management of the petitioner undergoing changes. Stop. List this matter after 6 weeks as prayed for. Next.
'98 Kotak Mahindra.
Lordship, in this matter also, there was a warrant of arrest against the judgment debtors by an order dated 24th March 2023.
Yes. Report আছে কোনো? Same order as we যেখানে বললাম না, to file a report. Same order.
93, Lordship, 93.
Same as 93. Next.
Item number 99 Kotak Mahindra.
Lordship, in this matter, there was a warrant of arrest against the judgment debtor number 2. The sheriff had filed a report. Lordship, the matter came up before your Lordship on 16 June when Lordship had directed them to give a translated copy of the report. Lordship, I have also taken instructions from my client. Lordship, this judgment debtors are not traceable. Lordship, in this scenario, I would wish to withdraw the execution application with liberty to file afresh when they are traceable.
The translated copy of the report of the concerned police station is placed on record by the deputy sheriff, by the department. Stop. The report states that the warranty does not stay in the address mentioned in the execution petition. Stop. Next, the advocate on record of the award holder submits that the award debtors are not traceable and wishes to withdraw the execution case. Stop. EC 3229 of 2021 is accordingly dismissed as withdrawn. Interim orders, if any, shall stand vacated, and warrants of arrest, if any, shall stand discharged. Stop. Liberty to file afresh.
Item number 100, Poonawalla Housing.
There is also on a waiting instruction from my client, Mala, but I
Can't
have-
hear you.
I'm also awaiting instruction from client Mala regarding the proceeding matter, but I have informed my learned friend that there are negotiations going on. I'm not aware, but they are saying negotiations going on. They are adjourned for 4 weeks, Mala. In the meantime, the matter will be settled. I will be told.
Yes, the advocate on record of the petitioner submits that the parties are exploring a settlement and seeks an adjournment. Stop. List this matter after 4 weeks as prayed for. The award debtor is represented. Next.
Item number 101.
Lordship, this is my
Fine.
execution application. There was a warrant of arrest against the judgment debtor number 1 by an order dated 31st March 2023. Sheriff has to file a report.
Aki order was 93. It is 31st March. Kirada. The report of the deputy sheriff is placed on record. Stop. The report states that the warranty is a daily wage labor and has shifted to a different state stop, a different state for work. Stop. The local police station does not have any information on the relocated address, and the villagers also on the relocated address. Stop. The report further states that the villagers will inform the police when the warranty returns to the village. Stop. What do you want to do?
Lordship keeps it after 1 week. I'll take instructions from my client on this.
Next, the advocate on record of the petitioner seeks an adjournment. Stop. List this matter on 21st July 2023. Next.
Hundred and two, Tata Capital.
Well, I am to examine the witness. Manu.
Lordship, I am on behalf of judgment debtor number 2, your lordship. He is present in the court.
Yes.
Lordship, may I submit? Lordship, I have filed one supplementary affidavit on 17th February 2023, disclosing some movable assets. An advocate commissioner was appointed. The advocate commissioner went to the place. He make inventory of all the movable assets and take the symbolic position. Your lordship, they are yet to sell those assets and appropriate it from the actual dues.
Yes, Mr. Banerjee.
My lord, these assets which my learned friend is talking about, taken by the receiver, my lord, under his symbolic possessions are all, my lord, appliances which are of 2006, 7, 8.
Appliances means what?
My lord, Godrej ACs, Godrej deep fridge, Godrej micro oven, LG ACs. But these are of no value as of today. My lord, if lordship wants, lordship can appoint a valuer also. We will make the expenses, will pay the expenses. But this is not going to fetch me more than 3 to 4 lakhs. My awarded amount is more than 2 crores. He is also, my lord, can bring in a buyer if he can give that amount, my lord, which satisfies.
Have you given, are there particulars before the court of the assets?
Your lordship.
They are.
Yes, lordship.
Price is not there. my lord.
Price
No, no,
is
no.
not
By way of what? An affidavit?
Lordship, by way of a report, your lordship.
Report. Dekhite ki report ache?
No, receiver's report.
So already a receiver has been appointed.
Yes, he was appointed. He wanted to surrender these assets. So the receiver was appointed to take possession, my lord, of all these, my lord, movable assets. But these are of no value as of today. If, my lord, my learned friend can sell them and, my lord, satisfy the decree, I'll be very happy. So kindly seize these, my lord. LG Smart TV, LG Smart TV, then my lord, microwave ovens.
So this is what a company? How do you have 7 LG smart TVs?
Lordship, I was the wholesaler of electrical appliances.
Very well. The receiver's report contains an inventory list showing 37 movable assets belonging to the award debtor. Debtors. Stop. Learned counsel appearing for the award debtors submits that these assets can be sold in satisfaction of the petitioner's dues, in satisfaction of the dues of the award holder. Stop. Next. Have you paid the receiver, Mr. Banerjee?
Yes, yes.
The receiver, comma, already appointed, comma, is hence directed to engage an empaneled valuer to value these assets, to value the assets mentioned in the list, and file a report by 21st July 2023.
Grateful.
Stop. List this matter on 28th July 2023. Stop. Where is your client coming from?
From Bardhaman, Lordship.
Yes, you want him on the 28th?
Yes, my lord, I know
Yes.
this will not fetch my lord, more
Very
than.
well. Yes.
Grateful.
I'm grateful, Lordship.
Next.
Item number 103, IDFC First Bank Limited.
This is my execution application, Your Lordship.
Yes.
While in order dated 16 June 2023, the respondents are directed to take proper instructions in this matter. Your Lordship.
Provided they are present in court.
Your Lordship, they are not present today, but at that time they were present. Because there is a settlement is going on between the parties.
No
and
one
that
appears
was
for the respondent award debtors. Stop. The award debtors were to take instructions on the last occasion. Stop. List this matter as a last chance to the award debtors on 21st July 2023. Stop. The advocate on record of the petitioner shall communicate this order on the award debtors.
Non-commercial division, examination of judgment debtors at 2 p.m. Item number 15, Poonawalla Housing.
Being my
Finance.
6 weeks time mind this matter, housing.
I can't understand. Speak clearly.
I'm appearing on, mean, the award holder mind this matter, the management is changing, matter, the housing finance has gone to some other person, matter. I'm waiting for instructions from my client, matter, what is the.
How much time do you
6
want?
weeks, matter, can you give, and in the meantime, I think.
The advocate on record of the petitioner seeks adjournment on the ground of the petitioner undergoing management changes. Stop. Next, list this matter after 6 weeks as prayed for.
Grateful.
Sixteen, Srimati Debaruti Sen.
You're for the judgment debtor? Yes. What was the last order passed?
My lord, the last order was passed to the respondent to prepare a copy and to give it to the petitioner on how we are supposed to give the money and all. So this is the copy of the letter we have communicated.
You have
to them.
given it to the petitioner?
Yes, my lord.
Yes. What is your instruction?
Lord, may I come up? Let the matter be passed over, my lord. May I come up with the instruction, my lord? Just.
Passed over?
Yes, my lord.
No.
Oh, sure.
Sorry, my lord. My lord,
Yes.
my lord, it might come back to your lordship, my lord, that they were asked to give some sort of direction as to how the payments would be made. We have got this figure of 9,50,000 and the balance which they're supposed to say that they will pay thereafter. But my lord, what I was humbly submitting,
So 35 lakhs is outstanding.
35 lakhs is outstanding. 3.5 has been paid. Now they say that they propose to pay on or before 28th July, 9,50,000. And the
You're
balance,
referring to which paragraph of the letter?
my lord, paragraph 2, 4th line from the bottom.
Yes.
Will be paid by the said purchase on or before 28th July 2023, as my lord has
Yes.
by check, and since encashment the said 9,50,000 in my account, the same will be paid to so and so immediately thereafter, preferably within a week. The said buyer also agrees to further purchase so and so of cutters of land for a consideration of 12,50,000, and since encashment the said so and so will be given. So what I was submitting, my lord, is that so far this 9,50,000 is concerned, they say 28th July. So if it can be made, if this can be put on record, and if we can wait till 21st or 22nd or whenever is the available day, when your lordship will take up this matter.
And what is this balance? 12 lakhs 50,000 will be paid after 1 week.
No, they say on or before 24th of April 2024. That is, my lord, that first I was submitting, my lord, first this
Yes,
amount,
yes.
initially let this amount
Yes.
come. Thereafter we'll see. Because we waited for 2.5 years.
The letter written by the judgment debtor to the award debtor.
Yes.
Award debtor to the award holder dated 5th,
The
dated
advocate on
4th.
record of the award holder.
To the advocate on record of the award holder dated 4th July 2023 records that the former, FORMER, former will pay rupees 9.50 lakhs to the purchaser within brackets award holder close brackets on or before 20th July 2023 by way of a check. Stop. Next, the letter is taken on record. List this matter on, you want to come back on 21st?
No, my lord, we have mentioned here that that cash will be given immediately after 1 week. So we are praying for 1 week time after 20th of July.
List this matter on 28th July 2023 as prayed for on behalf of the award debtor.
Because this portion be complied with, let us see how things go and then
Yes.
come back again. Deeply your pleasure.
Item number 17. 17, Mukesh Kumar Dandania.
I appear on behalf of the judgment letter number 2.
Here
Your
for
Lordship.
the award holder, my lord, we wanted to, after the judgment debtors had filed their affidavit of asset, my lord, we found that none of the properties are within jurisdiction. But we wanted to, my lord, withdraw this application, my lord, to be filed before the appropriate court. My lord, and particularly, my lord, the award, since the original is deposited, my lord, it has to be, my lord, I have to withdraw that. For that,
No,
my lord,
when did they file their affidavit of assets?
Lord, they filed their affidavit of assets. It is affirmed on 10th of January 2023.
10th of January.
Yes, 10th of January.
But you did not raise this point when I took up the matter in June or before the learned single judge in March.
March no, may not be, my lord, but June, my lord, I had taken this point that I am instructed to withdraw this
Very well.
application.
Yes, learned counsel appearing for the award holder seeks to withdraw the execution case on the ground that the execution application is required to be filed before which court?
Lord Barashat Court, my lord, because
Before the
properties-
Barasat court,
Lord Barakpur, within Barashat district.
within a court in the in a court within the Barasat district, within the district of Barasat. Stop. Next, EC 107 of 2022 is accordingly dismissed as withdrawn. Interim orders, if any, shall stand vacated. Warrants of orders, if warrants of arrest, if any, discharged. Stop. The original award is the petitioner may approach the department for withdrawal of the original award.
Lord, upon replacing with a copy, certified true copy.
And replace the same with a certified copy of the same.
Grateful, Lord.
Grateful, my lord.
Next.
Item number 18, Tata Capital.
Your Lordship, I'm appearing for the award holder. And on the last occasion, the respondents, the judgment debtors appeared and they prayed for time to file their affidavit of assets, but they have not filed yet, Your Lordship.
No one appears for the award debtors. Stop. The award debtors had taken time to file their affidavit of assets. Stop. List this matter on 21st July 2023. For stop, the affidavit of assets should be filed within the returnable date, which shall be within the returnable date. Stop. The petitioner shall communicate this order on the award debtors.
Deeply obliged.
That's here, one. Item number 1, Imars Mining and Construction.
My lord, I'm appearing on behalf of the decree holder. My lord, an out-of-court settlement was reached between the parties, so it's my client's instruction to withdraw the matter.
My Lord, I'm for the judgment debtor.
The award holder and the debtor are represented. Stop. Counsel, learned counsel submits that the parties have reached an out-of-court settlement. And the and hence seeks to withdraw the execution case. Stop. Next, EC 27 of 2021 is accordingly dismissed as withdrawn. Interim orders, if any, shall stand vacated, and warrants of arrest are discharged.
If my Lord may kindly record that my Lord decree has been satisfied, my Lord, because that is the terms of the my Lord settlement. My Lord, so that the
Counsel appearing for the counsel appearing for the award debtor submits that the decree, award or decree?
It's a my Lord decree.
Decree, my lord.
Judgment debtor হবে তাহলে judgment debtor submits that the judgment that the decree has been satisfied.
Grateful, my lord.
Grateful, ma'am.
Item number 2, Shashia Rooftop Solar.
I'm appearing for the petitioner. The petitioner is in advanced talks for settlement. The petitioner has entered into advanced talks for settlement with the
What is
respondent
advanced
number one.
talks?
Draft terms of settlement have been exchanged. So if some time is granted, perhaps the dispute will be settled, my lord.
You're for the debtor?
Worship, this is
And for the bank.
a contempt petition.
Oh,
for
it's a
invocation of
contempt, yes. The learned counsel appearing for the petitioner submits that parties have entered into a draft terms of settlement and seeks an adjournment. Stop. List this matter after.
1 week.
List this matter on 21st July,
Grateful,
2023.
your lordship.
Next.
Item number 3, in the goods of Honorable Chamria.
My contempt application, my lord.
I am opposing this application.
Affidavits are complete, my lord.
Copy of the rejoinder has been served on me yesterday.
Yes. Who are you?
My lord, I have filed an.
No, no,
application.
no. Who is the person on screen?
Ma'am, I'm a counsel. I'm one of the counsels for the alleged contender, my lord.
Mr. Biswas, possibly.
The screen is not showing him
No, it's not
over
showing.
there.
It's
Not
It's
showing.
not showing.
Tako, tako. Yes.
My lord, I filed an application for probate. In the probate application, my lord, I also filed an application for injunction against, my lord, the contender herein from dealing with any of the assets. Your lordship was pleased to pass an order on
Mr.
1st of.
Mukherjee, with regard to the notification, I will only pass ex parte orders against the petitioner from 2 o'clock.
They are present. Your lordship, once I can come back another day. No problem. I'm ready. Although.
Make your arguments, please.
My lord, your lordship was pleased to pass an order on 1st of July 2021 directing that the assets should not be transferred. My lord, my case is that after 1st of July, my lord, they made certain transactions, they sold certain properties, which was altogether 1.26 crores. I came up before your lordship, my lord, at that point of time, subsequent to these transactions, where, my lord, your lordship, by an order of 16th February 2022, directed, my lord, the respondent to deposit all the sale proceeds.
Yes.
All the sale proceeds. They say they have deposited only 1 lakh, and
That's
is the
page
only money.
106.
Page 105. Yes, my lord. Page 106. This is the order, my lord, from which, my lord, contempt have filed the contempt application. Your lordship will see the tenor of the order, my lord. My lord, the executor of the last will and testament of one late Anirudh Chamaria seeks further protection in terms of an order passed by this court on 1st July 2021. The 1st July order should be read as testament and not testimony. By the said order, an injunction was passed restraining one Neeraj Khanna from selling, dealing with, or alienating the Mussoorie and Salt Lake properties of the deceased. Neeraj Khanna was named as the vendor in the sale deed in relation to the property situated in Uttarakhand. The basis of injunction would be apparent from the order and hence is not repeated. Learned counsel appearing for the executor places documents showing that parts of the Mussoorie property have been sold to various persons by Neeraj Khanna, including the wife of the said Neeraj Khanna. The particulars given in the document show that the sale and alienation commenced from October 2020 and continued till 6 July 2021. Your lordship will note the total transactions are around 26 and they have received around 6.18 crores altogether from October 2020 to 6 July 2021. Thereafter, learned counsel for appearing for Neeraj Khanna submits that the said Neeraj Khanna became aware of the order of injunction only on 9 July and some of the properties have been alienated between 1st and 9th July 2021 amounting to a sum of rupees 1 lakh. That's what he said. Counsel also urges that section 213 of the Indian Succession Act would not apply to any property in Mussoorie. Without going further into
the further merits of the matter pending affidavits, Neeraj Khanna is directed to maintain the state of affairs as existed on 1st July 2021, which is the date of interim order passed by this court. Any amounts received by Neeraj Khanna from sale or alienation of Mussoorie property shall be kept with the registrar, original side of this honorable court. The amount should be deposited with the week from date. Neeraj Khanna is also restrained from taking any further steps in relation to the properties which form subject matter of injunction in the order of 1st July 2021 until the matter is heard on affidavits or until further orders, whichever takes place. The amount to be deposited by Neeraj Khanna should pertain to sale of Mussoorie properties after 1st July 2021. So after 1st July 2021. My lord, your lordship will now take page 59.
Yes.
This is a deed of sale of 5th July 2021 after your lordship's order.
After the order of 1st July.
1st July 2021.
Yes.
The lordship will see deed of sale dated 5th July between Neeraj Khanna, who's the seller, and one Miss Shubha Sen Roy. My lord, your lordship turns over to page 61.
Yes.
That, my lord, now this deed witnesseth as under that in pursuance of this deed, the total amount of rupees 17 lakhs has been paid by the purchaser to the seller as follows. My lord, very interestingly, if your lordship sees 8.5 lakh, but we did check number so and so, dated 1st September 2021. And again, 8.5 lakhs, we did check number so and so, dated 1st December 2021. This is the advantage, my lord, the respondent is taking now. And my lord, your lordship will find, my lord, from page 63, that my lord, the stamp duty has also been detailed. And my lord, clause 10 at page 63 also says that the purchaser shall be at liberty to get the said property mutated in his name in the municipal records of Mussoorie at his own cost, and also expenses of registration of this deed. So deed has been registered without receiving any money for 17 lakhs. And they say that the money has already been paid, but the checks are post-dated. This is the first deed. That's 17 lakhs. Now your lordship will turn over to page 78. This is a deed of sale dated 6th July 2021.
Yes.
Again, Neeraj Khanna is the seller and one Mussoorie Eco Park LLP is the purchaser. My lord will kindly turn over to page 80.
Yes.
Once again, my lord, this curious consideration, my lord, that in pursuance of this deed, the total amount of rupees 71,70,000 has been paid by the purchaser to the seller as follows. My lord, 25 lakhs, 25 lakhs, 20 lakhs, and 71,000, and all are again post-dated. Apart from, my lord, the last entry of 71,700, which is 6th July 2021. Money receivable in September, December, and February of the next year. And similar to the previous deed, my lord, if your lordship turns over to page 83, again, clause 10, the purchaser shall be at liberty to get the said property mutated in their name in the municipal records of Mussoorie.
Yes.
And there is no mention in any of these deeds that there is a consideration of rupees 1 lakh anywhere.
So
the
you,
checks which were there,
staked a claim on the Mussoorie properties.
Mussoorie property and the Salt Lake property. Well, they had sold the Mussoorie property, part of the Mussoorie property, even after your lordship's order of 1st July. When I come back, my lord, and point out that the sales have happened, your lordship had said, my lord, that they will put in the entire sale proceeds. Their submission before your lordship, they've received 1 lakh. My lord, these deeds will not show, my lord, the receipt of 1 lakh anywhere. They only show, my lord, the checks which have been paid are of specific value, 25 lakhs, 20 lakh, 98,000.
So 71.70 lakhs in one and
17 lakhs.
17 lakhs.
17 lakhs in the other. There is a third deed also, which is at 97, but that's a gift deed.
Yes.
Although there is a, my lord, if your lordship takes page 97, your lordship will find, my lord, a market value has been given, stamp duty is paid also, but sale consideration is love and affection.
Yes.
So, my lord, at least 71 lakhs 70,000 and my lord, a further sum of 17 lakhs ought to have been received by them. And there are checks which are also particulars of the checks are given. There is no check of rupees 1 lakh mentioned anywhere. Before your lordship, now if your lordship turns over again to your lordship's order of page 106, or the second paragraph, submission was made that they have Learned Counsel for Neeraj Khanna submits that Neeraj Khanna became aware of the order of injunction of 9 July and some of the properties have been alienated between 1st and 9 July, amounting to a sum of rupees 1 lakh.
Yes.
There is no mention of 1 lakh, no check of 1 lakh anywhere in these deed of conveyances. And now, my lord, if your lordship sees page 107, this is a report of the registrar, which says, my lord, that at least till 21st of February 2022, they have deposited only a sum of rupees 1 lakh with the registrar.
Yes. Anything else,
Yes, my
Mr.
lord. Now, if your lordship sees their defense in their affidavit, my lord, para 7 and para 8 of their affidavit, my lord, para 7, if your lordship takes the last 3 lines, starting with para 7 at page 7, last 3 lines of para 7, with reference to the list of deeds annexed and marked with annexure C to the instant application, I would like to specifically deny that an amount of rupees 17 lakh against transaction listed at serial number 21 or 71 lakh 70,000 against the transaction listed at 22 has been credited to any of my accounts as has been wrongly alleged by the petitioner. And then para 8, my lord, with reference to the statements and allegations in para 5 and 6, at the very outset, it is denied that the 5 deeds have been executed after 1st July. I say a total of 3 deeds were executed after 1st July, 1 sale deed of 5th July 2021. Malad, this is the deed at page 59, and 1 gift deed and 1 sale deed of 6th July. The 6th July deed is malad, page 78. I categorically deny that I have received a sum of rupees 1 crore 26 lakhs on account of sale proceeds of Mussoorie property. I repeat and reiterate that towards the transactions executed by me between 1st July 2021 and 9 July, I have received a total sum of rupees 1 lakh only. It is submitted that no consideration was received for the gift deed. I have not received any payment towards the said sale deeds thereafter. That the checks towards consideration of these 2 sale deeds were returned by me to the purchaser after I gained knowledge of the order of 1st July 2021 passed by this honorable court. However, if the honorable court may so direct, I can reiterate, reinitiate the 2 sale transactions and deposit all payments that the purchasers would make towards the same with this honorable court. That in the alternative, if this honorable court may direct, I can take steps towards cancellation of both the sale deeds and the gift deed executed post 1st July 2021. Well, there is no mention whatsoever in this.
So what is it
affidavit.
you want, Mr.
Lord, I
Mukherjee?
want contempt, an order of contempt, my lord. The checks, my lord, were there. There is no mention of any 1 lakh rupees
a rule.
I want a rule to be issued, my lord. He is certainly not coming truthfully in court, my lord, and they have violated your lordship's order. The submission that they've received 1 lakh is, there is no bearing whatsoever from the deed of conveyances. These are registered deed of conveyances, my lord. Stamped and registered, full stamp duty paid.
Yes.
They show 71 lakhs, 70,000 and 17 lakhs consideration paid. There are mention of checks with the particulars of the checks. There is no 1 lakh rupee check anywhere in those conveyances.
Yes.
Suddenly they come before court and say they've received only 1 lakh. There is no documentation on what basis that 1 lakh was received whatsoever. And if the checks were there, it ought to have been their duty to come and to tell the court that they have not encashed the check. They have not produced their bank statement to show that they have not encashed encashed the checks. There is only a bald statement which has been made that they've returned the check. They ought to have shown all the bank statements to show that the money has not been received by Neeraj Khanna. That's number 1. Number 2, my lord, they should have got a confirmation from the seller that, my lord, from the buyer, that the checks have been returned to the buyer. No document in support of those statements, my lord, which has been made. Number 3, and most importantly, my lord, possibly the mutation is also complete. There is no statement made. My lord, the deed of conveyance permits the buyer to go and have the property mutated. no money received, and on the other hand, possibly mutation is also complete. No statement, nothing whatsoever made, my lord, in this affidavit. What
That is all,
anywhere.
Mr. Mukherjee? You're not interested in the properties or the money?
My lord, I'm very much interested. I have an application also pending that is a separate application which is going to come up, my lord, on 21st of July, where I'm asking for the entire deposit to be made. And my lord, at present, my lord, what is happening? My lord, the contender is gainfully utilizing the property. This property is being let out, and my lord, they're financially.
No, but I thought it's a buyer and a purchase. It's a purchaser and a seller and a seller.
I will tell, my lord, this is a probate of a will. My lord, I am the executor.
No, I'm talking about the two transactions which you placed.
Yes, my lord.
Between Neeraj Khanna and the
someone
third
else, some
party. Yes.
outsider. My lord, here the entire cause of action, my lord, in my filing these applications is, my lord, I have the last will by which, my lord, the property is supposed to be devolved upon a trust, charitable trust. My lord, the will is also on record. He has a previous will on the basis of the prior unregistered will, which they say is not required to be registered, in as much as one of the properties is in Mussoorie. He is using the unregistered will for the purpose of selling off the properties. They have sold off properties worth 6.18 crores.
Yes, I remember. Mr. Mukherjee. Yes, Mr.
6.18
Medora.
crores.
How would you want to resist the rule?
My lord. But at the outset, my lord, my first submission is this, my lord, that this contempt application has been filed purely on the basis of conjectures. Not a single iota of evidence has been placed by my learned friend to show that I have received the sums he's claiming that I have received. In fact, to quote Mr. Mukherjee, my lord, he said a very interesting thing. This amount of money ought to have been received, but he's not said or not shown at all that I have received. And that is my case. I have not received these monies which he's claiming I have.
And what do you
received.
say about these two transactions?
So far as these two transactions are concerned, yes, these two transactions were carried out, undeniably that. The documents which Mr. Mukherjee has also shown that so far as the sale consideration for both these two transactions were concerned, post-dated checks were given to me, post 1st of July, post 9th of July. Those checks were never encashed by me. So therefore, I have not received those sums which I was to receive in terms of those checks which were handed over to me. In fact, my categorical statement in my affidavit in opposition is that I've returned those checks. Today, Mr. Mukherjee is coming on purely on the basis of conjectures and surmises. It's a fishing inquiry which he wants, because he made a statement, I ought to have disclosed my bank statements. If he's filing a contempt application, my lord, he should come up and bring the evidence which he has to support his allegations. He's coming up after nearly 1.5 years. The transactions took place in 2021. He comes up in 2023. And the reason why he's coming up, my lord, this is nothing but a counterblast to certain criminal proceedings which I've initiated against them, my lord, in respect of the second will, which is a forged will, according to my client. Mr. Mukherjee also made a wrong submission, my lord. He says his will is registered and mine is unregistered. It's the other way around.
I never said registered will. I said this is the last will, man.
No, he also said registered. Anyway, that is a payment. Mine is a registered will. His is an unregistered will. Yes, his unregistered will is a later will. But today, my lord, we're concerned, my
So,
lord.
Mr. Medora, have you made that statement in your affidavit that you have not, I've seen that you received only 1 lakh?
That's right, my lord.
Which was your position on before the court?
9th of July as well, my
Yes,
lord.
before the court.
That's right.
So
my lord.
apart from that, your stand is that you have not received any
I have not
money
received.
apart from 1 lakh.
I have not. I was to receive in the form of post-dated checks.
But the post-dated checks, those dates have also gone.
They've gone. I didn't encash those checks. Because by that time, your lordship's order was in place. So far as an injunction is concerned, and so far as depositing whatever monies I have received post 1st of July. He's not coming and stating that I've deposited those checks and received the money. He's imagining or guessing or conjecturing that I've deposited those checks and received the money. But where is the proof that I've deposited those checks? Purely on surmises, my lord. No question of contempt. No case of contempt has been made out.
Yes, anything else?
I have
Mr.
received rupees 1 lakh. I have deposited that in compliance of your lordship's order.
Yes.
So far as the third transaction is concerned, it's a gift deed. My learned friend fairly points out, my lord, I was not to receive any money in respect of that transaction in any event. 2 transactions, yes, executed, deeds executed. I was to receive money. I haven't received money. He's saying I should disclose my bank statements. It cannot be a fishing inquiry, my lord. If he's coming
As in PHYSHING.
also.
Yes. So that's all, Mr. Medora?
Yes, my lord. If lordship has any query, I'm ready to address that, my lord.
Yes.
My lord, my lord, your lordship will see, my lord, the conveyance deeds. They mention the deed of conveyances. It's not, my lord, imaginable they will not deposit the checks. And any event, my lord, I think in this kind of a case where, my lord, it's also an equitable jurisdiction of, my lord, probate, they ought to have disclosed particulars to show that the checks have not been deposited. There's a presumption here, my lord, that checks have been deposited. They've encashed the checks. And my lord, what about the property? The property mutation will also take place, my lord. My lord, they possibly has gone ahead, my lord, with that. And they make a bold statement here that they've not received the checks. They've not encashed the checks. Well, that is just a mere bold statement. Presumption on the basis of a registered deed of conveyance is that the checks have been encashed. They ought to have received the
Mr.
consideration.
Mukherjee, who is to discharge the onus in this case?
My lord, in this case, I am only to point out, my lord, the fact that as per the conveyance deeds, he ought to have received the money. The presumption is he has received the money. He has to rebut the presumption here, saying that the money has not been received and proving that they have not received the money. My lord, here, I cannot go and find out from his bank statement whether he has encashed it or not. He is the only one who can prove it that way. If at all that was the case.
What
And my lord,
does,
here-
I've forgotten the sections now. Is it 101, 102, 105 of the Evidence Act?
Yes, my
Just
lord.
check
Yes, my lord.
105, please. Who is to discharge that?
My lord, 103 is burden of proof as to a particular fact. Here, the burden of proof as to a particular fact lies on the person who wishes the court to believe in its existence unless it is proved by law that the proof of the fact shall lie on a particular person. But in this case, there's a
So both of
registered,
you wish.
there's a registered deed of conveyance which
Yes.
records that money has been paid. It is not, my lord, the money will be paid. The checks are, my lord, just a formality which has to be deposited. My lord, going back to the deed of conveyance.
So
your
both
lordship
of
will
you,
kindly
both
say-
of you wish that the court believes a certain state of affairs.
No, my lord, I only wish, my lord, not wish. I would rather say, my lord, your lordship will only look at a registered deed of conveyance, which the language used is that in pursuance of this deed, the total amount of rupees 71 lakhs and 17 lakhs in the other case has been paid by the purchaser. It is not a case, my lord, that these checks have been given. When there is my lord, there's a language used has been paid. So if the checks are post-dated, it means they ought to have been encashed. And it's a registered document. There is validity to that document as of today. He's not saying, my lord, that these deeds have been cancelled. His specific case in the affidavit in opposition is, my lord, that he is willing to cancel it. Your lordship will see para 8. Para 8. Last 4 lines. That in the alternative, if this honorable court may so direct, I can take steps towards cancellation of both. My lord, the language of a registered document, a public document, my lord, that has to be believed. I am showing that as a fact. The burden is on him to show that these checks have not been encashed. He is not, my lord,
Mr.
been able to-
Medora, I will do this. I will give you a week's time to bring evidence on record that you have not encashed these checks which form part of the two sale transactions. If you are not willing to do that, I will issue a rule. There's no question of you're not willing to do that. Either you file something or you file something without any content.
But your lordship is looking at what type of evidence, my lord, because I'm saying I have not received anything. And it's
will
difficult
disclose
for me
bank
to show that I have not
He will-
received something.
If the two transactions say that payment has been made
Yes.
by the purchaser to you,
Yes.
then you will have to show that you have either cancelled the checks or bank statements to show that you have not encashed the checks. And related to the check number, disclose all that, disclose the particulars.
So your lordship wants, my lord, my bank statements for.
Mr. Medora, that is entirely up to you how you will discharge that
May I
onus.
just indicate one small thing then, my lord? My learned friend is relying on those deeds, my lord, which says payment has been made to me.
Yes.
But those deeds also state the mode and manner of payment. all in the form of post-dated checks. So
Mr.
has
Mr.
been paid, my lord, has
Medora,
been read in, has to
those
be read
are
in
of
entirety.
July. Those are of July
Yes.
2021 or
Yes,
whichever the
2021.
year is.
Yes.
Now 2 years have passed.
Yes.
So many things may have happened in between. So you bring those facts on record to show that that nothing has happened pursuant to those sale transactions, and you have complied with the direction of the court that apart from 1 lakh, you have not received anything. Those are just statements in your opposition. Furnish proof. How you do that, that's up to you.
Very well, my lord.
Obliged, my lord.
The contempt arises out of an order passed by this court on 16th February 2022, by which the alleged contemnor was directed to deposit any amounts received from sale/alienation of the Mussoorie properties with the registrar, original side of this court. Stop. The alleged contemnor was also restrained from taking any further steps with regard to the properties which form the subject matter of injunction, subject matter of an order of injunction passed by this court on 1st July 2022. 1st July 2021. Stop. The alleged contemnor was also directed to deposit the sale proceeds of the Mussoorie properties which took place after 1st July 2021. Stop. Next, the petitioner, learned counsel appearing for the petitioner, has placed 2 sale deeds of 5th July 2021 and 6th July 2021, which record the alleged contemnor as a seller, and 2 other entities as the purchasers. Stop. Where is the description of the property, Mr. Mitra?
My lord,
Mr. Mukherjee? To show that it's in Mussoorie.
my lord, in page 60, the last recital, my lord. Page 60, the last recital, whereas seller has agreed
Yes,
to sell
yes.
Mussoorie
The recital, the recitals in the sale deeds show that the properties are situated at Mussoorie, are located at Mussoorie. Stop. The sale deeds, according to the petitioner, according to counsel, the alleged contemnor has received amounts of at least in excess of
17 is 86, 80,
90.
88 lakhs, 88 lakhs, 70.
88 lakhs, which is contrary to the stand taken on behalf of the alleged contemnor before the court on 16th February 2022, where the alleged contemnor had stated that the alleged contemnor had received only rupees 1 lakh, between 1st and 9th July 2021 from sale of the properties in Mussoorie. Stop. Next, the deeds, the sale deeds, the two sale deeds shows that the purchasers to the properties which was sold by the alleged contemnor paid an amount of rupees 71.70 lakhs plus 17 lakhs number to the alleged contemnor by a series of checks bearing different numbers and post-dates. Stop. Although the alleged contemnor has denied receiving any money from the sale transactions in his affidavit in opposition, comma, there is no evidence in the affidavit in opposition to show that to corroborate this fact. Stop. The checks are the checks which were the sale deeds record that the purchaser that the amounts have been paid by the purchaser to the seller, within brackets, the alleged contemnor, close brackets. And the checks are all dated between 1st 1/9/2021 hyphen 1/12/2021. 1/2/2022. 1/9/2021 hyphen 1/2/2022. Stop. The presumption would hence be, comma, unless evidence is adduced to the contrary, comma, that the alleged contemnor received the amount of approximately rupees 88 lakhs from the purchasers pursuant to the two sale transactions. Stop. There is nothing on record. No, the alleged contemnor must discharge the burden of proof in the present case, and there is nothing on record to show that the alleged contemnor has indeed discharged that burden. Stop. Next, the alleged contemnor is therefore given an opportunity to adduce, to bring evidence on record to disprove the allegations made on behalf of the petitioner with regard to the alleged contemnor receiving an amount of rupees 88 lakhs, contrary to the position taken on 16th February 2022. Stop. The affidavit shall be filed. How much time do you want, Mr.
2
Whittaker?
weeks, my lord.
The affidavit shall be filed within 2 weeks from date. Stop. List this matter on 28th July 2023.
I'm obliged, my lord.
Next.
Grateful, my lord.
Item number 4,
Lord, I
Prime
appear-
Cold Stores.
I appear for the petitioner, my
I
lord.
appear for the alleged
Lordship's order dated 21st September 2022, my lord, which is appearing at page 30, was challenged by, my lord, the state of West Bengal before the Honorable Division Bench. Lord, the Honorable Division Bench, by an order dated 20th June 2023, my lord, has been pleased to, my lord, uphold your lordship's order. If I may hand over a copy, my lord. Lordship's order, my lord. Only one thing, my lord, the compliance time which your lordship had granted initially 12 weeks, my lord, that has been extended from, my lord, the date of the receipt of a server copy of the order, of the appeals court order.
This set out portion is from which order? At page 2 of the division bench order. This is not my language. Whose order is this?
No, this is the order which was impugned in the writ petition, the order of the authority which was impugned in the writ petition.
Very well. So what you have been given more time, additional time to comply. So what do you want to do, Mr. Siddiqui?
I have to come back, my lord. My lord, we have been granted further 12 weeks. Your lordship has granted us initially 12 weeks time, my lord. Now that 12 weeks has been extended from the date of passing of the.
So now you have how much more time?
12 weeks, my lord, again.
12 weeks from?
From the date of.
No,
passing
this is not my direction. It's the division bench's direction.
12 weeks from 28th of January 2023.
28th of June.
2023.
Milord, it will expire on 28th of September, Milord, 2023, Milord.
28th of September.
September.
So when do you want to have this matter listed?
Any day, Milord, after 28th of September. So comments.
Yes, learned counsel appearing for the petitioner hands up an order passed by a passed by the appeal court presided over by the Honorable the Chief Justice, dated 28th June 2023, whereby the order passed by this court has been upheld. Whereby the order passed by this court on 21st September 2022 has been upheld. Is that the order which I passed?
Yes,
21st
Milord,
September.
at page Milord 30 of the contract.
Yes, has been upheld. Stop. The division bench, however, gave
Page 4.
the alleged contemnor Where do we find the 12 weeks, Mr.
The
Siddiqui?
time for lordship, can you come to page 4? The time for compliance of the order as ordered by the learned single bench shall
Very well.
commence to run from the date of.
Yes, the division bench, however, gave the alleged contemnor to comply with the order passed by this court within 12 weeks from the date of the order of the division bench, which is 28th June 2023. Stop. The 12 weeks will hence expire on 28th September 2023. Stop. List this matter on 29th September 2023.
Great. I'm good.
Yes.
Five, Mrs. Gatikti.
My application.
Yes.
We were to submit a written note. Madam. May I? Section 91. It looks voluminous for the judgments that have been enclosed.
Have you placed these judgments,
Yes.
Mr. Banerjee? You
Yes,
have.
yes.
And have you?
One was a superstructure.
No, and have you said which paragraphs
Yes.
are material, are
Yes.
relevant?
Yes.
The note says that.
Yes, not it does. At page 6, paragraph 10, one judgment is referred to. In page 7, paragraph 2, the other judgment is referred to.
Respondent number 4 is who?
Well, I'm for the respondent number 4, the private respondent.
Yes.
My lord had wanted points, so we
Yes,
had labeled
yes.
as points, my lord.
And Mr. Dotto, how will I know that this is your note? By a process of elimination. You're the bank.
Respondent number 1.
Yes, learned counsel appearing for the petitioner, comma, the bank and the private respondent have handed up their respective notes as directed. Stop. List this matter on 21st July 2023. So what I will do is just let me go through the notes if I have any questions, and then I will give the judgment. এটা একটু প্রীতমকে বলে দেবে যেন দেয় আমাকে। What is it, Mr. Banerjee? You want her note?
They took mine, so I also want something in return.
Yes.
Item number 6, Asif Latif.
My lord, I beg to appear on behalf of the petitioner. My lord, this is that matter where the official trustee has ousted me and wrongfully restrained me from using my tenanted premises at 37 Mirza Khalif Street. My lord, it was thereafter been 56C Mirza Khalif Street, Kolkata 7,60,000.
I can't understand. Speak clearly into the microphone.
Sorry, I am late, my lord.
Yes.
Lord, I appear for the respondent number 2.
Now, my lord, I am admittedly, my lord, a premises tenant of a shop room, my lord, which belongs, my lord, to the private respondent. It doesn't belong, my lord, to the Administrator General. It belongs to the Armenian College. Armenian College have a scheme going by which the Administrator General is looking after its affairs relating to its assets. But my challenge is totally different. I have been tendering rents, paltry by current standards, but 350 rupees and odd per month. And I've been doing that, my lord, without.
What is the current standard?
The current standard would be 6 times that amount, which I am ready when willing to pay.
And how much you're paying?
I am paying at 350. I'm ready and willing to pay at 225. It is 375. I'm sorry. And Lord, I am Lord ready and willing to pay 6 times that amount, because that is 17(4)(a) of the Vesical Premises Tenancy Act. But then that is something which the landlord might not accept as it appears from the circumstances. Issue is totally different. Why I have come in the writ petition. My lord, one fateful day, they came up to the premises. The agents of the official trustee and Administrator General came up to the premises and said that because I had sublet the premises to person X, they wanted to take over possession. They took over possession.
You were not supposed to do that.
According to them, I was not supposed to do that. I say that I have not sublet. But then that is yet to be adjudicated before any competent forum in accordance with law. They came up as an agent of the landlord, because the Administrator General is looking at it as an agent of the landlord in a scheme. So the Administrator General's officer or his person comes up and says, you have made subletting of a portion of your premises to a third party. Therefore, we are taking over possession. They took over the keys from me, Millard. And from that day,
they as in the Administrator General.
Yes, the Administrator General and his men and agents have taken over possession 3rd of December 2022. They have taken over possession of that shop room. They retain it even now. Yes. I moved, your lordships, my lord. Affidavits, my lord, were asked. Affidavits have been exchanged. In the affidavit, the plea taken by the Administrator General is that one Mr. So-and-so, he gives the name, voluntarily handed over the keys to me. That Mr. So-and-so is not me. That Mr. So-and-so is not the tenant. There's no letter of surrender. There's no surrender and giving over of possession. So whatever he prefers by way of an explanation is just a preference in despair. I'm only raising one question, Lord, for your lordship's
kind. In despair. Why would you say that?
Because, Lord, he has nothing to prove.
Not in desperation.
It's in desperation. It's in desperation. And my lord, a tinge of despair, my lord, added to it. Now, my lord, in answer, in my writ petition, the only question that I have raised is this. My lord kindly takes over, my lord, the Premises Tenancy Act. Premises Tenancy Act governs.
So is this what am I hearing? It's a contempt or a writ petition?
My lord, a writ petition finally being heard. Affidavits are complete. Everything is on record. By an earlier interim order, my lord's officer was pleased to permit the goods that were lying there for about from 2022 onwards to be removed. They have been removed.
Musical instruments.
My lord, musical instruments. Now it is under lock and key. Key has been
I
given-
wasn't very convinced about your case. Only because it was musical instruments I had allowed you.
My lord, I also, my lord, have a great my lord, fondness for music. But my lord, not the sort of instruments, my lord, that were there. They are, I am told, my lord, extremely rare German instruments. Persons having a taste for Mozart and Bach would, my lord, like them. I am a bit more, my lord, current style. Now, my lord, taking it forward. Now, therefore, my challenge, my lord, to the writ petition in the writ petition was only this. Kindly take a look. It's a single point challenge. I have no other challenge, my lord, to press. The West Bengal Premises Tenancy Act, my lord, governs tenancies of landlord and tenant. There is a capping of the highest amount of commercial rate of rent beyond which it travels beyond the Premises Tenancy Act and goes into the realms of the Transfer Property Act. Section 3 speaks of certain exemptions, certain kind of buildings owned by the central and state governments, owned by a central corporation under a central act, etc. They have been kept outside the purview. This building doesn't fall within any of the exceptions. So this is squarely covered by the West Bengal Premises Tenancy Act. In the West Bengal Premises Tenancy Act, even if 100 breaches of tenancy are made by the or perceived breaches of the landlord by the tenant, the only recourse that the landlord has is to file a proceeding for recovery of possession under Section 6. Would your lordship kindly take note of the provisions of the act?
Mr. Banerjee, will you do me a favor, please? Will you formulate your points today and come back and argue further on some other day?
My only 3 points which I am formulating for your lordship's kind consideration.
Yes.
First point, the property in question and my tenancy is squarely covered by the West Bengal Premises Tenancy Act 1997. Second point, under the West Bengal Premises Tenancy Act 1997, there are certain grounds for eviction or recovery of possession that are provided in Section 6 under the sub-clauses of subsection 1 of Section 6. If there's a breach of the tenant of any of these grounds, then the only recourse available to the aggrieved landlord is to file a suit for recovery or a proceeding for recovery of possession before the appropriate civil court in accordance with the provisions of Section 6. This Premises Tenancy Act does not permit a landlord to imagine a perceived breach and then to go and lock up the premises of the tenant, saying that I hereby take back possession because I feel that you have breached. This is not available to him under law. Secondly, the third point is, therefore, Premises Tenancy Act wise, the action is not supportable by law.
You are not the Administrator General. You are.
Yeah, no.
Who has
I represent the Administrator General official trustee. My lord represents the college, the Armenian college.
Then why are you saying no? You are the Administrator General.
Yes.
So that's the first point. The second point is the Administrator General functions under an act, which is the Administrator General's Act. The act does not give the Administrator General any power to evict any person from settled possession in any premises in respect of which they are exercising jurisdiction as custodians and oblique or agents and oblique or trustees, either appointed by a scheme sanctioned by the court or otherwise. They cannot throw or remove anyone from possession. This is not available to him. So his Parent Act does not permit him to do so. Thirdly, if any scheme has been framed by which the Administrator General has taken over custody of this premises for the purpose of its upkeep, even if in that scheme there is a provision that he can summarily throw out a tenant or lock up his premises, that would fall flat in view of the provisions of Section 6 of the Premises Tenancy Act. There's a non-obstante clause in Section 6, which says, notwithstanding anything to the contrary contained in any other law or order or judgment of court, etc. There's quite a thick non-obstante clause. These are the grounds and this is the manner in which you can dispossess a tenant and in no other manner. There, my lord, I fall back on, my lord, Taylor versus Taylor. If you cannot, if the statute says that you can do it in a particular way, then you have to do it in that way alone. All other forms are necessarily forbidden. There's an additional aspect, which is the last point, my lord, which I'll take. Under the Indian Penal Code, without any lawful excuse or justification, if a person who is residing in a premises and has a right to enter the premises is prevented from entering the premises, this constitutes a criminal offense. If the official trustee or the administrator general, with great respect, is unable to show any legal basis for the exercise done by him or his agent, then he would fall foul of the provisions, my lord, of the Indian Penal Code. Wrongful, my lord, restraint, my lord knows. If I have a right to go and a tenant has a right to enter the tenanted premises unless prevented by an injunction of court or unless evicted by in execution of a decree of possession made by a court, a landlord cannot usurp that right, arrogate to himself that right. If he can't do it, his agents under any scheme, under any provision, cannot be given that right. Lord, these are my points.
Thank you, Ms. Banerjee. Yes, are you done? Or when do you want to? I can hear Mr. Nondi. On the next one.
I can just know the next day, whatever I've submitted, nothing much further to submit in terms of the points. On each point, Lord, I'll just not waste your lordship's time too much, Lord. A judgment or two, Lord, on each point, so that, Lord, I can buttress my submission by law.
One judgment per point.
My lord.
Yes, learned counsel appearing for the petitioner has made the outlines of his submissions. Has placed the outline of his submissions. Lists this matter. Tell me, please, 21st, 28th, when?
21st, my lord. The earlier the better.
On 21st July, 2023.
Oblige your lordship.
Next.
Item number 7, Pratyusha A MRG JV.
Respondent.
Who is for the petitioner?
My application under section 11. But before I start, my lord, I must indicate when an application under section 9 is being considered by your lordship, my lord, and that is fixed on my lord, 11th of this month.
But I'm saying it's not arbitrable because barred by limitation. So ex posse barred by limitation. Well, there
Barred by limitation. The claim is barred by limitation.
the substantive claim is barred by limitation.
And aren't there judgments, Mr. Mukherjee, that the arbitrator can decide?
No, my lord, if the in section 11 at the reference court will decide if there is a ex posse barred by limitation. That, my lord, the reference court has the jurisdiction to do.
You're referring to the Allahabad High Court?
My lord,
judgment?
BS Supreme Court, my lord, BSNL, and also, but this honorable court has also decided on those lines, my lord, following the Supreme Court judgment. Ex posse barred by limitation is the substantive claim, and that the pre-reference court can decide. We nipped at the bud.
Lord, I'll show your lordship 4 documents by which I would attempt to satisfy your lordship that my claim is not barred by limitation. My lord, kindly takes my lord, volume 1 of my application.
Mr. Dashgupta, just give me your points, please.
Yes, my lord, contract between the parties, my lord, contract for construction of
You're the
national
contractor.
highway. I'm a contractor. My lord, the disputes arose due to the respondent's defaults and my lord breaches, where I suffer certain losses, which I claim from the respondent. Now, my lord, I intimate them in 2016, September 2016, that I have suffered losses. Thereafter, they say that their original employer, they are some arbitration disputes are going on between the respondent and its original employer, where my claim has also been considered, has been inducted. They receive my claim, the respondent receives my claim, and then inducts all my claims in their reference with the original employer. But that I say, but that happens in 2018. I intimate their claim.
48 lakhs or something.
72 lakh is my claim. 72 lakh is my claim.
No,
I'm sorry, 72 crore.
Didn't you say 48 or 49? There was a Delhi High Court judgment.
Yes, not 49, but 14 crore they had released from the Delhi High Court, which the Delhi High Court has ordered them to, by way of furnishing a bank guarantee, they were allowed to take the money out. But my section 9 was to that extent, let them not appropriate that amount, so far as the sum has been released from the Delhi High Court. But that is my point. But in 2016, I intimate them that I have suffered loss and I quantify my loss to the extent possible. In 2018, they say that my claims have been considered and inducted in their own claim, in the respondent's own claim, in the arbitral reference with its original employer. So, well, in 2018, according to me, that is an admission on behalf of the respondent of my claim.
So my lord, in 2018, my period of limitation gets refreshed by another 3 years. Thereafter, my lord, in 2019, I invoke the arbitration clause, which is there between the petitioner and the respondent before your lordship. So my lord, 2016, I incurred the loss. I claim damages. 2018, there is an admission on behalf of the respondent. 2019, I invoked the
When have I
arbitration.
kept the section 9?
My lord, on 11th of this month.
11th. Come back on that date, please.
Right.
Yes, the application for interim relief between the same parties is to come up on 11th July 2023. Stop. Next, learned counsel appearing for the petitioner has placed his submissions, made his submissions. Stop. List this matter on that date along with AP
That is AP 370 of 2023.
370 of 2022.
Only 2023.
370 of 2023.
Only one difficulty, my lord, this section 11 has been filed before the regular division. Will your lordship kindly consider this application to be transferred and tagged along with the section 9, because this involves commercial dispute and the subject,
What is the claim amount?
my claim amount is 76.92 crore.
The section 11, namely AP 370 of 2022.
No, my lord,
No, my
AP,
lord,
370
of
863 of 2022 is the section 11, and section 9 is AP 370 of 2023.
Yes, the section 9, which is AP 370 of 2022, is before the commercial division. Stop. Since the petitioner's claim is approximately rupees 72 lakhs, comma, let the present section 11 being AP 863 of 2022 be transferred, be sent to the commercial division.
But 72 crore.
72 crore.
Well, the affidavit of service may be kept.
Yes, the affidavit of service is kept on record. The department shall take necessary steps as directed in this regard. Stop.
I'm grateful.
Item number 8.
Lord, before my learned friend starts, my lord, I've just offered him some settlement because the amount that he's claimed is so little, my lord. The litigation cost will exceed that figure. So, my lord, if your lordship can keep it next week, any day, my lord, we can
Offered him what? Money?
settlement.
He has off. On the last occasion, my lord, the matter was urgent, Lord. It fell from lordship that we should serve them and come back, my lord. There you go.
Yes, sir. Learned counsel appearing for the, this is a what? This is a section?
Section 11.
11(6).
Learned counsel appearing for the respondent submits that the respondent has made an offer of settlement to the petitioner. Stop. And seeks an adjournment. Stop. Next, list this matter on 21st July 2023 as prayed for. Next.
21st.
Item 9. Is ECI engineering.
My lord, I'm appearing for the petitioner, my lord. My lord, this is a section 29A, subsection 5 application for extension of the mandate for arbitration.
Your service, please. Interview capital site. There is no tracking report. When did they receive it?
My lord, we have served upon the advocate on record, my lord, by hand.
Very
my
well.
lord.
No one appears for the respondent. Stop. The respondent's presence is required since this is an application for extension of the arbitrator's mandate under section 29-A of the 1996 Act. Stop. List this matter on. They have to be here.
Yes, madam, 1 week.
List this matter after a week as prayed for.
Keep
Yes, any original side matters which are there? Yes, appellate side.
Milord, there was a contempt matter, Milord, fixed at 3 p.m. Would it be Milord's pleasure to take it up?
Yes,
I am
3
for the
PM.
contempt.
Yes.
Contempt application, Jalpaiguri Circuit Bench.
Mr. Shah, you're waiting for a matter? Which one?
Another contempt matter. Well,
No, in the Jalpaiguri bench?
No, not in the Jalpaiguri.
Yes, yes, it will be taken up
Yes,
right
yes,
after this.
and
Yes.
Manoj, this is that matter where a lady employee had made allegations against a superior of sexual harassment. And in retaliation to that allegation, a show cause notice was issued, Malad, to the lady. Now, that show cause notice was impugned in a writ before my lords. And my lords was pleased to allow the writ petition, quashing the show cause notice and also directing that no further steps must be, no further effect should be given to the show cause notice. My lord,
The employer had given the show cause notice.
yes, the employer
And the allegation of sexual harassment made against the employer.
made against a superior. Yes, a superior within the company. It's a government company. Now, my lord, two documents were, my lord, impugned in the writ petition. One was a warning where I was let go with a warning, but there were allegations leveled against me. And then after the warning was issued, I took this up further with the police authorities because the company didn't do anything. So once the FIR was registered, just after that, my lord, the show cause notice was issued for those same allegations which were closed in the warning. So I impugned both the warning and the show cause because I'm not admitting any of those allegations. They are pertain to, my lord, some infractions at my workplace, alleged infractions at my workplace. So my lord then quashed both the warning as well as the show cause notice. Now, they have now prepared an appraisal report, which, my lord, is a report for every employee. This report has to be prepared annually as per the rules of this organization.
The person who has prepared your report is a person against who you made the sexual
Against whom I
harassment.
made those allegations. And this was made after the registration of FIR, after issuance of show cause, and during pendency of the writ, the report was prepared. But once the order in the writ was passed in August 2022, that no further effect is to be given to that show cause. After that, this report now has been published on the website in January 2023. Now, as a consequence of this report, I am now ineligible for promotion. I'll show my lords the rules as to what is the significance of this report. It really can make or break my career. And this is an annual report which is prepared, and the reports prepared in the last 5 years have immense weightage in whatever I do in this organization, be it my promotion, my other benefits, perhaps, if I'm applying for a job elsewhere, which I may actually consider, given the hostility I'm facing here. Even then, they'll scrutinize these reports and decide whether to recruit me or not. So this really, the publication of this report, in fact, the preparation of this report itself is really, my lord, in the teeth of this order passed by my lords. May I just place?
How do I know that the person who has prepared your appraisal report is the one against who you have made the sexual harassment?
The author's name is there in the report. I'll place the report before my lords. So, my lord, kindly allow me, my lord. Today, my lord, apart from, my lord, praying for issuance of rule against one of the contemners, my lord, I am praying for these adverse remarks in the report to be expunged and for me to be evaluated afresh by someone other than the person against whom I made allegations. It's, my lord, a very simple prayer that I have. And, my lord, I have a judgment to cite if necessary that in contempt jurisdiction, my lord may first purge the contempt and then perhaps go on to deal with the act of contempt and decide whether to punish the contemners or not. They may perhaps say that they misunderstood the order. But at the end of it, even if the orders, my lord, even if the actions are in violation of the order, then they have to be purged.
And the assessment was made after the order was passed by the court.
No, assessment was, my lord, now the assessment has been published in January, but the date of preparation is 31st July. Now that the writ
And
was
what
being
is the-
heard.
What is the date of the order?
11th August 2022. So the writ was being heard. It was heard on 4 or 5 occasions, my lord, over a course of 2 weeks. During those hearings, it appears that this report has been prepared. And the rules, my lord, the rules, there is a rule under the 2013 Act. If I may just place the relevant rule.
That's the Sexual Harassment Act.
Yes. The rule says that other reliefs that a complainant during pendency of an inquiry may be entitled to, the organization will restrain the respondent from reporting on the work performance of the aggrieved woman or writing her confidential report and assign the same to another officer. So the act itself, the rules provide that if there is a pending inquiry, he could not have really evaluated me.
Mr. Ghosh, the issue is something much more fundamental.
Yes, yes. The only unfortunate part here.
Mute. Mr. Ghosh, you will not talk when the court is talking. That's the rule I follow, and you have to follow that.
Yes, madam.
The more fundamental part is, how can a person against whose sexual harassment allegations have been made appraise the employee?
If Millard, I am permitted to respond, Millard, the facts which have been brought before your lordship, Millard, has been curated only to canvass as if, Millard, the organization is a culprit. What has been grossly suppressed, Millard,
Not
what has
the
been
organization. Not the organization, the person concerned.
Millard, what has been grossly suppressed is, even prior to Millard delivered the judgment, that was on Millard August, Millard, these statements which Millard pointing out to your lordship has been reviewed, Millard, that has been discarded. Millard, the grading of this employee has been, Millard, entirely changed to good, which is, Millard, a very reasonable parameter. Now, Millard, kindly takes Millard's order, the operative portion at page 237.
1 minute.
Millard.
What has been changed to good?
Millard, her entire evaluation. The reviewing authority who had reviewed the performance appraisal has stated.
Mr. Ghosh, don't treat giving of a good remark as vindication of what you have done.
No, Millard, it's not that. Millard, the entire remarks which was recorded against this employee, the reviewing and accepting authority had subsequently expunged those remarks. That's reviewed. And Millard, her performance, which was shown to be poor, was upgraded to good.
What is the best category you have?
Millard, that's outstanding. That's outstanding. And Millard, against this.
Mute করে দাও তো। আমি যখন বলবো তখন unmute করবে, তার আগে নয়। Why should the employee not be given outstanding or any category above good? Unmute.
So far as our promotion policy is concerned, and Millard, the evaluation parameters, Millard, I have also called for the gradings of this employee for the last 5 years when she was not even posted at this location, when she was in the headquarters. Millard, she has never received, Millard, the grading it to the Millard, an outstanding grading. It was always good, very good on that range. And Millard, that is consistency which is being followed. Millard, she has neither been, Millard, graded somewhere which is, Millard, out of her average performance.
Mr. Ghosh, you follow a practice of average grading on the last 5 years performance.
No, Millard, I am saying if an employee is ranked outstanding for 3 years and now suddenly ranked as poor, that would, Millard, shock the conscience of this court. Why this has happened?
Mr. Ghosh, absolutely not. You're making submissions which are totally incredible.
Now, Millard, someone who has, Millard, who has been
mute করে দাও. An employee has to be graded in accordance with his or her performance for the last 1 year or whatever the time period is. This kind of submission last 5 years did not get outstanding, did not get very good. This is completely incredible.
Me a specific question. Millard is asking me a specific question why we should not grade her as outstanding. No, Millard, I am only saying, Millard, in the last.
Mr. Ghosh, please. I thought you were a better counsel than this. That is not the question. The underlying reason for that question is your submission that her grading was changed from poor to good. That's why.
Yes.
So you're treating it as some sort of an expiation of your guilt. No.
No, Millard, certainly not, Millard. Millard, why her score was subsequently increased? Millard, it's objective. Millard, allow me to produce the review report. It is objective, and Millard, most interestingly, the parameters on which the employee likes to be evaluated is set by her. She himself sets the parameters. In Millard, this organization, NHPC, it is the employee who sets the parameters. That these are my objectives which I intend to fulfill in this particular year. And Millard, on the basis of the parameters which are set by her, the authority evaluates whether she has been able to fulfill these parameters or not. And Millard, is objective. Not something, my lord, someone wishes to get someone as good or outstanding.
Mr. Ghosh, is it correct that the person against who the allegations were made
Yes, my lord.
party to the appraisal? Is that
Yes,
correct?
yes, that's correct. But it is also, Millard must also note this, that when she accepted to the authority of this particular person for herself to be evaluated, she has not objected to that. She, the initiating authority who will initiate the performance appraisal, Millard, is known to the employee. She has set the parameters herself. She has discussed with this authority, and Millard, thereafter, Millard, this process started. And this was
Mute. Mr. Ghosh, prima facie, you will have to get somebody else to make the assessment.
Millard, that can be done. That can be done, Millard. That's not an issue.
No doubt that I will direct that. No matter what you say, no matter what Mr. Lakmani says, that has to be done first.
But Millard, since that has now been reviewed, Millard, if Millard wants to revisit the process, Millard, it can be done, but it has been reviewed. And
Whether reviewed, not reviewed, poor to good, whatever, nothing has to be done by an independent person.
And Millard, this issue, Millard, so far as the performance appraisal is concerned, was not a subject matter of the writ petition, neither it was urged before your lordship.
Court will correct the course. The court will correct your course, and your course is not correct.
May I just add, reviewed by another person without there being any weightage given to the allegations which were quashed. Naturally, that's all that I'm allowed praying insofar as my interim prayer is concerned.
Mr. Lakmani and Mr. Ghosh,
Millard.
and you're appearing for all the alleged contemnors?
Yes, Millard.
The relevant rule, my lords, is at page 316. If your lordship may kindly once have a look at page 316.
Who is the alleged contemnor? 5 of them?
All, my lord.
And who prepared the appraisal?
Millard, the appraisal was, Millard,
contemnor number
Millard, the contemnor number 5. Millard, who has prepared the initial, Millard, appraisal, then Millard, it has been reviewed and accepted by the respondent number 3, who has, Millard, changed the entire appraisal.
But not to our knowledge.
Admittedly, the alleged contemnor number 5 is the first party to an appraisal made of the petitioner's performance in the last 1 year. Is that correct? 1 year or more than that?
Yes. No, my lord,
It's 3.5 months since December.
For performance from December 2022
21
from December 2021 hyphen till
31st March 22.
31st March 2022. Stop. The defense taken on behalf of the alleged contemnors is that the appraisal done by the respondent number 5, respondent number 5, the alleged contemnor number 5 is the person against who the petitioner leveled allegations of sexual harassment under the provisions of the 2013 Act. Stop. The next, the defense taken on behalf of the alleged contemnors that the appraisal given by the respondent by the alleged contemnor number 5 was reviewed by the alleged contemnor number 3, and the appraisal changed from poor to good, poor quotation marks to good quotation marks.
Sorry, my lord, may I just interrupt? My lord, it's numerical. So from 37 on 100, it has been taken to 52 on 100. That's
within brackets 37 to 52 out of 100 close brackets is no defense at all, since the person against who a complaint of sexual harassment has been made cannot, under any circumstances, be a party to the performance appraisal of the complainant. Stop. This offends all concepts of equity and fair play apart from the provisions of the 2013 Act. Stop. Next, the alleged contemnors cannot treat the relative improvement of the scores / grades given to the petitioner before the court, within brackets, complainant in the sexual harassment proceedings, close brackets, as a vindication of the unnatural and unfairness adopted by the alleged contemnors. Stop. Next. The contempt, admittedly, the appraisal was prepared while the writ petition filed by the petitioner was being heard by the court, and the result of the appraisal was published on the website of the.
Millard, it was never published in the website, Millard. I am sorry to interrupt, Millard.
How did you make it known, the appraisal?
Yes, Millard, in the website of the NHPC, Millard, there is a self-service portal which is akin to an email account. There is a Millard unique user ID and a password through which each an employee can log into their own account. The reports are uploaded in that personal portal.
Appraisal, ki bolam, and the result of the appraisal was completed and uploaded on the website of the company for being viewed by the petitioner after the court delivered the judgment in the writ petition on 11th August 2022.
No, Millard, it was uploaded on 30th of July, the reviewed performance appraisal report prior to Millard's judgment in her personal portal, Millard, not the website.
Before the court delivered the judgment on 11th August 2022, stop. The appraisal was uploaded on 30th July 2022. Stop. Next. Before going into the allegations and counter charges made by the parties, the alleged contemnor must, the alleged contemnors, particularly the alleged contemnor number 5, must, are affidavits done in this?
No, my lord.
No, Millard.
Prove that there has been no contumacious violation of the judgment and order passed by this court on 11th August 2022, and must also show that the alleged contemnor number 5, that the performance appraisal of the petitioner was unconnected with the charges leveled by the petitioner against the alleged contemnor number 5. Stop. Next. Affidavit in opposition by 21st July 2023. Reply within
a week thereafter.
28 July 2023. Lists this matter on 4th August 2023.
My lord, in the meantime, may I just pray, my lord, kindly do not let the report be available anywhere. My lord, it has to be deleted. I may show the report.
I thought, Mr. that it is a personal unique number which.
No, my lord, the seniors, the superiors in the organization can view it. People who sit on my promotion.
No, Millard, I have taken specific instructions, Millard. It is not visible to anyone except the employee. Millard can record.
Needless to say, until further orders are passed by the court, no one in the concerned company, where is it, Shiliguri?
It's in the
Millard, NHPC Kalijhora, Millard, Tista Lower Dam 3.
Yes. no person in the concerned company will make the appraisal known to the others, to any other person in the company, or circulate the appraisal for or circulate the appraisal within the company which may have a bearing on the fate of the contempt application. Stop.
I'm grateful, my lord.
Next.
Grateful.
Item number 1.
I don't understand. Is this the time to mention? Why don't you follow the list? You're just coming and mentioning. You don't even know what is the time to mention. Yes, call on the list, please.
Well, an appeal has been preferred by my learned friends
One
against your
minute.
lordship.
Yes, Dekecho, item.
Item number 1, daily list.
Yes.
Sigma Rail.
Well, my learned friends have preferred an appeal against your lordship's order. My lord, the division bench is hearing the matter. It's kept next on the 13th. My lord, we have told the division bench, my lord, that we'll come and represent your lordship so that.
13th.
Yes, my lord, it's kept on the 13th. We're hoping that the
That's
matter will
next
be.
week. So
Yes.
tell me, Mr.
My lord, may I request, my lord, for the 19th or the 20th? We should be done by then.
Mr. Shaha, I take up these matters
see.
only on Fridays, the contempt. This is a contempt. So tell me, give me a Friday.
21st, 20th is Friday.
I can put it on the 21st.
Well, at 21st, my lord, I am in some difficulty, but if your lordship permits me to join virtually, my lord,
Yes, of course.
grateful.
Why, you can always do that.
I'm grateful, my lord. 21st.
Yes, learned counsel appearing for the petitioners submits that the alleged contemnor, that the alleged contemnors, not the alleged contemnors, that the respondent in the writ petition has challenged the judgment and order passed by this court on, where is it?
17th May 2020.
May 2020.
17th May 2023, and that the appeal is due to be heard on 13th July 2023. Stop. Next list this matter on 21st July 2023 as prayed for.
Grateful.
But Mr. Shah, just ensure that somebody is here as well, so that
Yes,
if
yes.
I need to see any documents or
My
something,
lords,
then.
my lords.
Yes, call on the next matter, please.
Item number 2, Kushina.
My
Lord, I am appealing for the respondent.
my lord, this is the first time contempt application. My lord, on 19th of July 2022, your lordship has been pleased to dispose of the writ petition on the basis of a prayer made by the Learned Council for Union of India that they will comply with the undertaking given before the Alipur court to grant linkage within, and the said writ petition was disposed of, directing the respondents that within 3 weeks thereafter linkage has to be granted, my lord, upon consideration of my representation.
Linkage? What
Linkage with the Vahan e-module, my lord, with the
Yes.
vehicle registration system. My lord, the judgment is at page number 61 to 63.
So what is it that you want today?
My lord, thereafter on 28th of July 2022, I have served the contempt notice, my lord. It has not been acted upon. Thereafter, they have filed a 340 application before the learned court below. My lord, that was also dismissed by the learned court below, my lord. My lord, these are the aggravated acts of contempt, my lord. They are not complying with the order. They have not preferred any appeal.
Who is they?
My lord, the respondents, my lord. I'm sorry, my lord.
So you're coming up against or this is in contempt of the judgment dated
19th of July
19th
2022.
July.
Page number 61, my lord, onwards.
Very well. When do you want to come back with? It's first time.
My lord, I'm just instructed. I just got instructed that the Matter was dismissed for default due to the lacuna of the advocate on record for the GOI.
Which matter?
That miscase, 340 application.
Give me details of that. Who
My lord,
dismissed
my lord,
it? What is
My
this?
lord, I'm giving you, my lord. This is an
This is the way you
application.
make submissions in court.
My lord, I've just instructed that 340 application filed by the government of India. They are saying that.
Yes, learned counsel appearing for the alleged contemnors does not have the requisite facts to make submissions in court. Stop. When do you want to come back?
1 week.
List this matter on 21st July 2023. Next.
Grateful.
Item number 3.
I am for the petitioner in this matter.
I appear for the condemned.
Lord, Your Worship, kindly state will come to page number 20.
I can't hear you. Microphone, please.
Page number 20 of the contempt application, wherein my lord's direction was to pass the order directing the respondents to act in terms of the letter of the government of India dated 6th of July 2022. Lord, in spite of the same, they have what they have done, Your Lordship, kindly see that they are impugn order. They have sanctioned the pension with effect from 27th of September 2019 instead of 4th of August 2019. That is the date following the date of the death of my husband.
I don't understand. How is this in violation of the order? Yes.
They have not,
No, the order does not mention any date at
No,
page 21.
In the order, it has been stated, Your Lordship, kindly see the letter. In the letter, it has been said to pay.
I can't
Lordship,
understand. Yes.
regarding the payments,
And
Lordship.
No, I can't understand. your
Lordship, before my
submissions.
learned friend proceeds.
Yes.
There has been discrepancies in the spellings and the documents that she has produced.
Yes.
Therefore, even there is a letter sent to my learned friend on 3rd of July, asking her to deposit all the documents with one spelling. Any discrepancy in spelling we cannot issue a PPO. So
Yes,
that has to be
So
solved.
do that. Why do you want to
That
proceed
must
with the
be
contempt?
solved.
Do that.
Only 1 minute, because for that reason I got submission.
I can't understand what you're
Only
saying.
the one, instead of A, in the name of my
Yes,
hair,
that is
in the order of my lord, Chakraborty has been spelled as BORTY. Instead of A, in all documents, it is BARTY.
Then that
And
should be correct.
in the application and order.
Are you interested in getting the pension or are you interested
I'm
in doing the
interested. So
contempt?
what I'm saying, Your Lordship kindly pass an order to teach them the spelling of my title as BARTY instead of BO. Only this correction may be done.
That is what.
Only in the order sheet, it has
Even in the application, they had that discrepancy. Let them file. We've been asking for documents. With
all
and your
documents
lordship's
are
also corrected.
correct.
Because the order also.
If you make simultaneous submissions, I'm going to dismiss it. You always disturb the court. Don't do that.
Lordship, the order also reflects it's BORTY. And she has used both the spellings in her application as well as her Aadhaar card and PAN card. I think it's BAR. So there has to be one.
So what is it? It has to be BAR.
The Aadhaar card and PAN card show BAR.
So if I pass an order, will that make it easier for you?
And then she has to put in all the other applications that they've asked for with BARTY. There are two. I mean, there are two spellings that she's also used.
Very well. Learned counsel appearing for the alleged contemnors.
Only
Submits
number 4. The bank
alleged
is not
contemnor number 4 submits that the petitioner has been called several times to the office of the
office by the office. We've been asking for the documents from Delhi. Even my learned friend.
No, what I can't understand. You are asking for documents.
Yes.
From
we are,
who?
we from the petitioner.
So that's what I'm saying. Please don't
Yes.
interrupt.
হ্যাঁ।
কি বললাম?
শুধু এখানে অর্ডারটাই আছে আর সব দিয়ে দিয়েছি।
But to the office of the respondent number 4, to the office of the alleged contemnor number 4 for furnishing appropriate documents with the corrected spelling of the petitioner's surname. Stop. Both parties, learned counsel appearing for both the parties submit that the petitioner's name, that the petitioner's surname should be spelled as quotation marks CHAKRABARTY, close quotation marks, and that there is a discrepancy in the surname of the petitioner, in the spelling of the surname of the petitioner in the documents which have been given to the respondent number 4, to the alleged contemnor number 4. Stop. Next.
All the documents are BA, only of my lord's order is BO.
CPAN 144 of 2023 is accordingly disposed of, with liberty to the petitioner to take appropriate steps for correction of the surname wherever required. Stop. It is clarified that the orders and judgment passed by the court, that the orders passed by this court should have spelled the petitioner's surname as CHAKRABARTY. Stop. The alleged contemnor number 4 shall hence take expeditious steps to release the
That has been released, but
been released already
no, it's not been released in sense, it's been sanctioned, Lordship. The sanction has been passed.
to
But
disburse
disburse.
the pension to the petitioner within, shall I give a time frame, Miss?
Lordship, from the receipt of the documents, whether that has been received or not.
Within, no, give me a reasonable time frame from the time that you receive the documents.
Maybe, yes, from the, about 4 weeks from the receipt.
Within 4 weeks from the
the receipt
time
of the
the petitioner, from the time the document, from the time the alleged contemnor number 4 receives the documents from the petitioner.
Deeply pledged.
Stop. Learned counsel appearing for the alleged contemnor number 4 says, submits that the pension amount has already been sanctioned and is pending disbursement.
In the sanction order, there is also BO written as
I
my
can't
lord's order
understand
was spelled as
what is it,
BO.
Miss Alam?
Again, this is as discrepancy in the spelling. Lordships have corrected that.
My lord's order has been corrected. Your lordship kindly directed them to correct their order of sanction. That has been sanctioned in the.
I've directed that. I've directed that. Thank you, Miss Alam. And please sort this out because it's just that it's a pension.
small,
Don't,
yes,
if there's so much of delay, then it's a problem for the petitioner.
Number 2 million. Item number 4.
In this matter, I am for the petitioner. Lord, in spite of my lord's direction, nothing has been done, no steps, in spite of repeated requests for the same. Lord, I have annexed my lord's order at page, my lord, at page, my lord, 29. And my lord's categorical direction at page 30, second paragraph. Well, I have served all the containers with my lord's direction. They have received. Well, the Union of India directed them to pay the amount.
We have got nothing to do, my lord. This is the bank, my lord, they are not.
Have you served the bank? When?
I have served, my lord. My lord, I have, as per my lord's direction, I have communicated, then also served the copy of the application. Lord, your lordship will service return is at page 33, 34 and 35.
It's 1st July. So you,
Not
yes, you come back on 21st, you communicate this order. Yes, the respondent.
My lord, can it be, my lord, either 23rd or, my lord?
No, it has to be on a Friday.
No,
It's a Friday.
Because, my lord, on 21st, I got a P.
I'm asking you, choose a Friday. I'm putting it on the 20th.
Any Friday, any day.
Yes.
Yes. Except 21st.
The material alleged contemnor is the bank, is the is the Punjab National Bank. Stop. The Punjab National, the said contemnor, the said alleged contemnor is not represented despite being served. Stop. Next, this matter on 28 July 2023. Stop. The petitioner shall communicate this order on the alleged contemnor number 3 and stop. The alleged contempt, if the alleged contemnor number 3 remains unrepresented, comma, this court will proceed to pass appropriate orders.
Particular 4, 5, and 6, not 3. Bank authorities are 4, 5, and 6.
4, 5, and 6. Next.
Item number 5.
Item number 5.
I appear for the petitioner, my lord. My lord, I passed an order on 21st November directing the concerned authority to dispose of the application for mutation which was filed in the year 2017.
Yes.
My lord, pursuant to my lord's order.
I
my
can't
lord,
hear you. Microphone, please.
My
Yes.
lord.
It's coming up for the first time.
It's coming up for the first time. My lord had indicated service, which service has been,
Where is the order?
my lord, the thing is they ought to have passed it by 23rd
Where is
January,
the order?
but they have already passed the order. Page 59.
Not they. It's a
My lord,
contempt.
the
So
co-
where is the
the-
order of the court?
Yes, my lord, comes to page 50, my lord, at page 68. Page 68. Page 68, my lord. My lord's direction is at page 69.
Yes.
WPA 19845 of 22 is disposed of with a direction upon the respondent number 3, the land manager, to dispose of the application within 8 weeks from the date of communication of this order, but not later than 9 weeks from today. The copy of the reasoned order shall be made available to the petitioner within a week.
What application was this?
Application for mutation, my lord, which was filed in the year 2017 before them. My lord, they ought to have, my lord, the contemnor, alleged contemnor ought to have passed the order by 23rd January. My lord, they have passed the order, which was received by me on 4th July 23. My lord, I think after service of, this is the order which has.
So what is the contempt? That they have not passed it within time?
My lord, now that I have received the order, my application.
I don't think anything remains of the.
Yes, my lord.
Yes, learned counsel appearing for the petitioner submits that the alleged contemnor, that there is an admitted delay on the part of the alleged contemnor in complying with the order passed by this court on 21st November 2022. Stop. Counsel submits that contrary to the direction given on the department, capital D, to dispose of the application for mutation within 8 weeks from the date of communication of this order, comma, which should have been, give me the date, please.
23rd January 2023.
Which should have been 23rd January 2023, comma. The petitioner received the order only on 4th July 2023. Stop. Next. Counsel, however, submits that since the petitioner has already received the order, comma, the contempt proceedings may be disposed of. Stop. Next, CPAN 608 of 2023 is accordingly disposed of in terms of the above.
My lord, one humble press subject to my lord.
Yes.
My lord, the original, they have dismissed my application. The original records are with them, with the alleged contemnor. Can an order be passed to return the, so I may challenge this order again.
Challenge which order?
My lord, the reasoned order there.
But you don't need the leave. You can always challenge that.
No, my lord, the original documents are retained by them, by the alleged contemnor.
No, I cannot pass that direction because this is only with respect to the non-compliance of the order.
Yes.
So
I bow down. I bow down.
Yes, that relief you will have to get from the writ court. From
I
where
bow
you
down
filed.
to.
Yes. Next.
Item number 6.
The affidavit of service is kept on record. Next.
Service to ওটা নামাবো তুমি এটা ছাড়ো না
I appear for the petition. my lord.
আমায় দেখে দিতে হবে
Yes.
This is a contempt for the first time, my lord, but I will be praying for a rule. Or you also will remember, my lord, if you also kindly see your
First
lordship.
time rule. No, Mr. Bandyopadhyay.
Absolutely gross violations, my lord.
Very well. You come back on the next day, I will hear you and then, but the first day without them. And when did you serve them?
No, this is appearing for the
Yes,
first
yes,
time.
right. No, not a rule. You serve them and then we shall see.
Only one contemner only. That is the tender matter, my lord.
The ESI hospital, Serampur.
ESI Sirampur. The documents which were discarded, in fact, bid was the same reasoning was put and he was my lord, allowed to continue.
Where is my order?
My lord, at page 52 it starts. 11 paragraphs you also will find from paragraph 7, 8, 9, page 55 and 56. And kindly see their, my lord, evaluation that was not communicated. Only after our notice it was communicated. My lord, kindly take, my lord, it starts from page 65, that 11 paragraph 7, 9 and 10. Exactly, my lord, the grounds which are, my lord, set aside by your lordships, my lord, that was made the basis of, my lord, continuations.
Very well. This is the contempt arises out of a judgment and order
Third memo.
passed by this court on 3rd May 2023. Stop. List this matter. Give me a date, please, Mr. Bandyopadhyay, 28th, whenever you want.
21st.
List this matter on 21st July 2023. Service to be made in the meantime. Service in the meantime. Next.
Grateful, ma'am.
Item number 7.
My contempt application.
Microphone.
Lord, this is my contempt application. My Lord, on the last occasion, your lordship had directed them once again to comply with the order. Lord, they've complied, but my Lord, I wish to rely on a supplementary in order to bring on record, my Lord, the manner in which they've complied, or rather, my Lord, it's a feigned compliance, because my Lord, it's contrary to what observations were laid down in the order, my Lord, which is in contempt before your lordship. Lord, this is completely different, and my Lord, the observations and findings which were laid down on the basis of which, my Lord, the directions were sought for, the directions were passed by your lordship, my Lord, it's completely different, and they remain to stand by their my Lord, their findings which they have made in the 13-2 notice, my Lord, the demand notice, which your lordship had held that was not valid. So, my Lord, I wish to rely on their, my Lord, their consideration, the purported letter, my Lord, which they've my Lord, I've served them also with a copy of the supplementary.
I appear for the alleged contempt, my Lord.
Yes.
I have, my Lord, lordship passed an order, my Lord, to make a consideration, my Lord, strictly, my Lord, in accordance with paragraph 24 of the, my Lord, initial order, my Lord, passed by your lordship, which is, my Lord, at page 30 of the contempt application, my Lord, which is 30th of March 2023. Lordship clarified in the contempt order, my Lord, which, my Lord, I was directed, my Lord, that, my Lord, I have to consider strictly in accordance with the directions as paragraph 24. That is, the eligibility has to be considered in accordance with the relevant, which is at page 40 of the contempt application. The eligibility of the petitioner shall be considered in accordance with the relevant ECLGS and the resolution framework which apply to the petitioner's case. I have exactly done so, my Lord. I have held, my Lord, he is SMA 2 because, my Lord, his account statement did not become zero as on 29th, my Lord, February 2020.
So what is it? You want to file an affidavit in opposition?
If lordship permits that and keeps it on 20th July, I have some difficulty in the next week. Or
No, it has to be on a Friday, so you can choose.
28th July
May I only
is a
indicate one
Friday.
thing?
No, 20th July is not a Friday.
Yeah, 28.
Oh,
Yes,
28th.
yes.
28th, 8.
Yes.
Only one thing, my Lord, my learned senior has submitted that he's made, my Lord, the compliance in terms of paragraph 24 of the order in contempt. Lord, indeed, yes, they've complied, but my Lord, the compliance itself has aggravated.
Very well. Let them file an affidavit. Yes. Upon hearing learned counsel opinion for the alleged contemnors, comma, one or more than one.
My Lord, there is one.
Alleged contemnor, comma.
So, my Lord,
And
they have
then
contempt laws, my Lord.
there are many, my Lord.
Yes.
They have all come.
Alleged contemnors, comma. Affidavit in opposition by, yes.
My Lord, I'll file it, my Lord, by 21st. Let the
By
matter appear on
21st,
28th. My Lord.
21st July 2023. Reply.
Not a week.
Week.
Not a week.
Reply by 28th July 2023. List this matter on, you want it on 28th or 4th?
No, 28th, your lordship.
list this matter on 28 July 2023. Reply in the meantime, Gurudat. Yes, next.
Assignment item number 8.
I am for the petition.
I am appearing for the priority.
Yes.
My lord, I am representing the state, my lord. My lord, my submission would be, my lord, I am restricting to my submission.
Just, I will hear you for 3 to 4 minutes and I will rise after that. So
Yes,
just,
yes, my lord, I will
formulate your
take
point.
5 minutes time. I will take 5 minutes time, my lord, so that I will complete
Yes.
that. My lord, here, my lord, the writ petitioners made a contention, make a contention to that effect. First, for seeking preferential treatment on the basis of earlier circular. Number one. Number two, my lord, he has challenged the vacancy notice on the, mainly on the ground of eligibility criteria, which speaks of 50 lakhs. That is capital you have to show. My lord, and third, my lord, that he made a contention to that effect that there is a favoritism. State wants to give appointment in favor of the private parties. My lord, here, my lord, so far first point is concerned, my lord, regarding preferential treatment. He is seeking, my lord. My lord, kindly come to stateway page 123. 123 of the paper.
Just tell me, formulate
My lord,
your points, please.
123 says that that notification has been, that circular has been subsequently amended on, my lord, that is, my lord, will find, my lord, 18 December 2018. And after that, he has filed the instance writ petition. They are in that amended, my lord, circular. There is no such preferential treatment so far the self-help group is concerned. Number one, he did not challenge this amendment regarding where the preferential treatment will not lie. And subsequently, my lord, he has filed this instant writ petition seeking the preferential treatment as a self-help group. There I join issue. First, he did not challenge that circular, that the amendment, which has done away with the, my lord, the preferential treatment so far self-help group is concerned. And second, my lord, he has challenged the vacancy notice. That vacancy notice says mainly on the ground that 50 lakhs is an arbitrary one. But my lord, kindly consider the vacancy notice has been issued on the basis of a circular or, my lord, statutory control order, my lord, provisions of the control order 2013. He did not challenge that. He simply he did not challenge that circular, on the basis of which authority has fixed the criteria. So for 50 lakhs is concerned. And my lord, he even did not challenge. My lord, and so for the third part is concerned, third contention, that there is a favoritism that state authority is going to give the appointment in favor of the person. That is not correct because that stage is yet to come. Because so many participants have, my lord, participated in this tender. And my lord, the evaluation is yet to be done since my lord has passed an order of injunction. So my lord, this is the point, my lord, I am making. It's a very simple point. And my lord, I will show only two judgments. My lord knows that regarding fixation, even if for argument's sake, assuming but not admitting that without challenging that earlier, the circular on the basis of which the 50 lakhs has been incorporated in the tender notice. My lord, if my lord, it shocks the conscience of the, my lord can, but my lord,
shocks the conscience.
The 50 lakhs, he has made a contention. Now it has come down to 25 lakhs. He made a statement, but my lord, these are the omnibus statement, my lord, because he has to challenge the
omnibus,
because the statement he has given, my lord, it is not part of his main writ petition. Subsequently, he has taken that point. My lord, whatever it might be, when he has taken this point.
Yes.
My lord, now, my lord, kindly consider 50 lakhs, my lord, that point of time when that, my lord, that 50 lakhs was introduced, my lord, and my lord, there was like 5 rupees 5 for one kilo. At that point of time, he has to charge because
I can't understand. What is the point?
point is, my lord, my point is, my lord, 50 lakhs is not an arbitrary because of the fact this objective and the subjective was taken into consideration
But
at that point of time.
wasn't there a rollback of the 50 lakhs?
50 lakhs, yes, it has come down because
So-
now
so
it is
then
a free
how is-
ration.
How is it relevant?
Now it is a free ration. Need not pay. Consume the
How is it relevant if there has been a subsequent rollback of the 50 lakhs?
50 lakhs.
Then how is it relevant?
My lord, may I give a reply? 50 lakhs, my lord, kindly see the advertisement. My lord, kindly see the advertisement which
Very
is
well. Mr. Shengupta, you have to come back on some other day.
yes, obliged.
But I'm going to give you 5 minutes on the next.
Yes,
Mr.
yes, my lord,
Shengupta.
only I'll just
formulate the point. That's all. And
Yes.
I don't know why this 50 lakhs remains relevant anymore because you've rolled it back. Then
yes, but it is not applicable so far his case is concerned.
and what is the on what point do you want to place judgments?
Well, regarding the terms of the tender, regarding the judicial, my lord knows that judgment.
No, I don't know. What judgment do you want to place?
My lord, that is judgment on, my lord, that is, my lord, based on, my lord, judicial review. State can choose this, my lord knows that
State can pick and choose.
its own method to elevate us. It can fix.
State can pick and choose on that.
State can choose, pick and choose, not state. This is not my saying. Well, this is the judgment, my lord, which I have. The state can choose its own method, my lord, to arrive at a decision. It can fix its own terms of invitation to tender, and that is not open to judicial scrutiny. My lord, I am not saying it is not my.
Which year?
My lord, that is 2014, 3 years.
2014. You better look at judgments of 2022 and 2023.
Yes, my lord, but
it says just the opposite.
But my lord, if there is an arbitrariness, if my lord sees that there is an arbitrariness, certainly my lord can take go into that whether there is arbitrariness.
I hope this is not the only judgment you have to cite.
My lord, only 3 judgments. My lord,
Before 2014.
After 2014. My lord, my lord, my lord, only thing, my lord, so far I have understood, I have to, my lord, make my submission on the basis of T20 format, not in the state format. T20 cricket.
Whatever it is, you will get 5 minutes, Mr. Shengupta, on the next day.
Yes.
And just formulate your points and
Yes,
give the judgments. That's all.
Yes. Obliged.
Mr. Bandyopadhyay was leading you or was appearing for somebody
Mr.
else?
Bandyopadhyay was leading.
Yes. No,
Yes,
Mr.
finished it.
Bandyopadhyay was appearing for the
Private respondent.
private respondent.
Rather added respondent.
And Mr. Basu, you're also for the private respondent. Very well. Learned counsel appearing for the state will conclude his submissions on, give me a date, please. Is this contempt or just, no, it's an assignment.
That's the assignment.
Yes, 19th or 26th.
My lord, I leave it to my lord.
The later, the better.
Later. My lord,
List
always,
matter
my lord,
on 26 July 2023.
the privilege to appear before my
Order is till 30th.
30th. You remind me on 26th.
obliged. It is our privilege to appear before my
Everyone says that.
no. This is my personal. Obliged.
Ma'am.